for delivery of a judgment. Item number 1.
The appeal is dismissed.
Actions. Learned counsel for the state was given at the last occasion, my lord.
What I'll suggest is this relates to reorganization, which is a policy matter. So my lords may direct the revenue department take a decision within a time fixed.
All that won't work, sir. This is a 2013 matter. Who's the secretary? We'll ask him to remain present. And you pay exemplary costs, sir. We're not taking this lightly. This has gone on for too long. Because as it is a 2013 matter,
Yes, my lords.
and then we give a specific order on 21st March 2022. That is 9 months ago.
Yes.
And for
Yes.
9 months, this government is unable to file an affidavit. That's a bit too much.
My lords,
This court was informed on 21st March 2022 that the reorganization of blocks will take some time at the government level. And therefore, this court had permitted government to file a further affidavit, giving 3 months' time about the steps taken to implement the decision to combine the Padampur and Paikmal blocks. This is the same Padampur for which election was held.
yes,
Yes,
my lords.
yes.
Yes, my lords.
Yes,
Yes,
my
my
lord.
lords.
This is same
That
one.
is
Ah.
in Bargarh district.
Bargarh district. my lord.
Ah.
Yes, my lord.
Good stop.
5 Gram Panchayats with Padampur block, my lord.
What we've written here is combining the Padampur and Paikmal blocks.
Yes, my lord.
Yes,
When on 29 June 2022, no such affidavit was on record. A request was made for more time, which was granted to the government. So again, a further 3 months was granted. Paragraph. And after 3 months, further time was sought. Then on 27 September 2022, a last opportunity was granted to file an affidavit on or before 14 November. Full stop. Nothing has been done so far, and only more time is being sought. Full stop. The court finds that granting of adjournment for about 9 months was sufficient time for the government to file an affidavit in the matter. Paragraph. By compelling this court to again grant an adjournment, great inconvenience is being caused not only to the petitioners but to the court as well. Full stop. For causing this adjournment, costs of rupees 25,000 is imposed on the government, which will be paid to the
My lord,
High Court Welfare Fund.
may I submit one thing? The lordship may direct that within 1 week we'll file,
All
otherwise
that
cost
only
will
after
be,
paying costs, sir.
otherwise we'll pay the cost.
No. For-
Within 1 week only, 7 days time.
To the High Court Welfare Fund, High Court Bar Association Welfare Fund, and proof of payment of costs will be placed on record. Paragraph. At this stage, Mr. Mohanty states that positively the affidavit will be filed within 1 week's time, that is not later than today is 14th December 2022. Full stop. If no such affidavit is filed by that date, who's the officer, sir?
Well, it's Secretary, Revenue and Disaster Management.
The Secretary Revenue and Disaster Management, Government of Orissa, will remain present either in virtual mode or physically to explain the inaction on the Parliament. A copy of this order be sent apart from the Secretary Revenue Disaster Management to the Chief Secretary as well. Forthwith. List on 3rd January.
Can it be less than 25,000? Oh,
These days, inflation has gone up. So correspondingly, it has to reflect
no,
the
that's
cost.
7 days and without fail, he will
No,
personally appear.
That is all over, sir. That was last time. Last opportunity was last time.
That we will comply.
Now we'll have to. Sorry, sir.
Item number 3.
May I please, my lord? My lord, I may be pardoned, I am through virtual mode, your lordship.
Yes.
My lord, on the last occasion, your lordships were pleased to issue notice in the matter so far as the appeal is concerned, and it appears that the notice on respondent number 5 has been solved as per the tracking report. Now, these
Your lordship, we are appearing on behalf of OP number 5, my lord.
on 29, 2022, your lordships were pleased to issue notice, my lord.
All right.
My lord. Here the appeal has been filed, my lord, challenging the order of the Honorable Single Judge.
You're ready with the matter, correct?
No, my lord, I have not got some relevant.
You're waiting for us to ask you. Otherwise, the argument will
I am
go on.
seeking an adjournment, my lord.
You're seeking it after we are asking you. Do you really want an adjournment?
Yes, my lord.
Then you should have said it right in the beginning. All right. Counsel appearing for opposite party number 5 enters appearance and seeks time. This is who's entering appearance, Mr. R.N. Biswal or?
Yes, my lord. Mr. Sharan Bishwal and
Mr. R.N.
associates.
Biswal, Senate counsel for the opposite party number 5 enters appearance and seeks time for filing a reply. But was a reply not filed in the main writ petition, sir?
My main writ petition, in fact, was dismissed, my lord, as it appears without any, my lord, counter affidavit has been filed. At page, your lordship will find the impugned order page 2.
Oh, I see. All right.
That can be referred to. Here in appeal, no reply is necessary, but if my friend wants to collect relevant material, man, that is different.
All right.
For assisting your lordship. He was OP5 and he has filed counter.
They have filed counters.
Mild.
Okay, and seeks time to address arguments. That's enough. No need for counter. It is already there.
Mild.
At her request, list on. March 8th. Oh, sorry, 8th is a holiday. 9th March. 9th March.
Obliged.
My lord, the brief has been transferred to Mr. Prafulla Kumar Ratho, my lord. And last evening, my lord, there is some mishap, my lord, for which there was some short circuit in his chamber, my lord.
In P.K. Ratho's chamber, there was some fire incident.
Last evening, my lord.
So
That's why I could not be tested out, my lord.
All right. The court is informed that Mr. P.K. Ratho, counsel has entered appearance on behalf of the appellant and is in some personal difficulty today. Fifth April.
My interim order to continue, my
All
lord.
right. Interim order to continue.
5.
Your my lord, in this case, the respondent number 1 died, my lord. Has died on 5/7/21. I have filed an application for substitution. I have served copy on.
What is the number, sir?
Respondent
670. IA number 670, respondent 1. I was appearing for the respondent 1.
670 IA number 670 of 21.
670 of 21?
Yes, my lord.
This cost list says 1670.
No.
670.
167.
I'm
167.
sorry, my lord, the mistake. That made a mistake.
It is 670. My copy shows that it is 670.
670. One double miss out. One is
See the hard copies.
Let notice be issued to the LRC.
IA number 1670 of 21. For the reason stated therein, the application is allowed. And the amended, you already filed the amended cost title, the consolidated.
no, my lord. I have not.
The consolidated cost title be filed within a week. You are appearing for whom, sir?
This is respondent 1. Let notice.
Who's for
be
2
issued
to
LRC.
4? Because the AD card to 2 to 4 has been returned with the remark left.
Yes,
Are you
my
aware
lord.
of that?
My lord, I am not in a position to know their address, my lord. It may be notice may be dispensed with, my lord,
Why?
because they
File
were
an
not.
application. You can't simply drop parties like that, sir. Are they necessary parties or not?
They are not contesting, my lord. They didn't contest in the.
That is very different, sir.
I will take fresh steps. Not.
The notice to response 2 to 4 has been returned with the remark single quotes left. The appellant will ascertain the present correct address of response 2 to 4 and file it in the registry within 4 weeks. Thereafter, fresh notice returnable. 12th April.
Madam, I may pardon me, Lord. Let notice be issued to DC, LRC of DC respondent 1.
Yes, yes, sir.
You are
Notice will go to the LRs of this spot. I thought you were appearing. You
I
are not
was
appearing for them.
approved for DC respondent 1.
All right, all right.
But the interim order is
Notice to, interim order to cut. Notice to the LRs, the substituted LRs of respondent mobile. Same, returnable on the same date.
6,
None of these dismissed.
7,
None of these dismissed.
8,
I may please your lordship. This case, my lord, the third copy of the impugned order is not filed, for which there has been a defect. Lordship, my lord, the writ application was disposed of at the stage of admission without notice to the private opposite parties. And I have quoted the order in the writ appeal. Lordship, may turn to page 4 of the writ appeal. There I have quoted the order. I could not obtain the certified copy. It was filed, my lord, in a hurry. There, Lordship, may see, I am permitted to place paragraph 3, page 4, my lord. Had Sri Nayak, Lord and Counsel appearing for the petitioner, considering the limited request involved herein, this court disposes the writ petition with an observation that in the event any application for ROR at the instance of the petitioner is pending before the Tahsildar Maneswar, opposite part number 1, the same may be disposed of by taking into consideration the order in mutation case number 158 of 2017 by taking a decision appropriate within a period of 1 month from the date of communication of the certified copy of this order. But the prayer in the writ application, I may draw your lordship's attention. I have annexed, annexure 1 is the copy of the writ application I have annexed. Lordship may see the prayer. In the writ application, private parties were there, but no notice was issued. The prayer was at page 13, so Lordship will see, the petitioner therefore prayed that the Honorable Court be pleased to admit this writ application and after hearing the petitioner's advocate issue a writ in nature of mandamus or other suitable writ directing the Tahsildar Maneswar to issue a mutation ROR in favor of the petitioner as for his order dated 29/1/2018 in mutation case number 158 of 2017. This mutation case number 158 of 2017 is not pending. The petitioner was not seeking any relief in respect of mutation case number 158 of 2017. They were praying that in view of the order passed in mutation case number 158 of 2017, the other mutation cases may be allowed. And the London first, the single judge mallet, without issuing notice to the private parties, though there is a suit pending mallet in respect of other mutation cases, disposed of the writ application with a direction to consider in view of the decision in the past in the mutation case mallet. Well, your lordship turn to page 9 and 10.
What has happened after this order?
After this order, my lord, mutation cases have not been concluded. Those cases are
Going on for 3 years now.
yes, my lord. But the mutation cases are
It will
still
be open to you,
pending.
sir, to challenge that in accordance with law. If something happens, nothing seems to be happening.
Lordship, give me that liberty and
All
dispose
right,
of-
counsel for the appellant seeks liberty to challenge the mutation order. Mutation, if any, carried out pursuant to the impugned order of the learned single judge in accordance with law. Granting that liberty, the court is not inclined to interfere with the impugned order.
My order
The writ
passed.
appeal is disposed.
My order passed in view of mutation case number 158 of 2017.
What was impugned order? We've said that's
9,
Madam, may I please, Your Honor, my lord. There is a one defect is there, can we remove, my lord? By next week, do I remove the defect? Is we have challenged the order of the honorable single judge in the Anganwadi matter.
15 days. Tell us.
My lord, can it be next week, my lord?
No. Go on adjourning, sir.
My lord, it is a case, is challenged before the honorable single judge. Is order dated 29/8/2019, wherein the honorable single judge dismissed the round that our appeal is pending before the sub-collector. But the facts remain that I am working as a petitioner appellant was working as an Anganwadi worker, and she was assaulted. FAR is it was annexed. See the NH2, there is a FAR. He was tried to killed by a particular groups by set firing by the kerosene oil, and she was admitted in the hospital, and a matter has been taken to the knowledge of sub-collector, and this CDPU and the other officials are involved. They are involved in the for disengagement of the work. And by this disengagement, they are claiming that you, because against the order of disengagement, you have to file the appeal for the sub-collector, which cannot be because it is a case where there no safety regulation is there according to the Anganwadi worker is concerned. Well, I am praying, my lord, that so many Anganwadi workers they are being assaulted. There is no regulation, no rules, nothing is there to protect their interest, my lord. Here is the case. We have annexed the annexure 2 and 3. Lordship may see the CDPU who engaged. Lordship may see for a moment page 15. That is page 15.
Mr. Padi, there was already an advertisement, fresh advertisement issued for filling up the post, correct?
My lord.
That was issued in July 2019.
Yes, ma'am.
We are now in December 2022.
But
There's been no stay, there's been no interim order in your favor.
No, there is not admitted. That's why.
So what's the point, sir? Now it's all been filled up. There must be somebody else in post.
My rights cannot be gone through not because I am working as long period. Thereafter, they are forcibly tried to assault me. When I was admitted in hospital, in that period, they have discouraged me. And to whom I will approach, he will be going for advertising the against the press advertisement.
Or you say during the pendency of the writ petition itself, a fresh advertisement had been issued 2019 for filling up the post of Anganwadi worker in several Anganwadi centers, including the one with which the present appeal is concerned. Stop. There has been no stay of the impugned order of the learned single judge dismissing the appellant's writ petition, declining to interfere with the impugned order, disengaging her. Full stop. Clearly, the new incumbent must be in position for over 3 years now. And there's no question of now putting the clock back to accommodate the present appellant. In that view of the matter, in view of the subsequent developments, This court is disinclined to interfere with the impugn order of single judge. The writ appeal is dismissed.
May I pray one
Delay
thing?
is condoned.
May I pray one thing? Let's
Yes,
make
please.
the liberty. If there is an advertisement, it is not prejudice the interest of the petitioner, he can apply the sum. If
No,
so,
no, not now, sir. Not now. Yes.
Item number 10.
May it please your lordships, with this matter, PIL was filed to say protect certain villages which are the subject of recurrent elephant attacks, my lords, and many villagers have died.
We are already dealing with this, sir.
No, my lord, this
In another PIL, we are dealing with these issues.
my lords, one is that to protect them from the villagers from attacks that provide irrigation to this place. The earlier project which was made, it had the canal surrounding the villages around the hill, so they could have been protected. They changed the plan of the irrigation project, and now they are open to the attacks of the elephants. They are not able to protect themselves. In case they make some effort to protect themselves, my lord, if the elephants are injured even, they are being arrested and acted upon, because it's very difficult for these poor villagers to protect themselves.
Correct, correct. So all these issues we deal with a different PIL. So no need to repeat these PILs.
It's not only, my lords, protecting them from elephant attacks. This is a particular, if the irrigation canal is taken as per the original plan, they will not only be protected from the elephant attacks, it will also provide irrigation. They have also provided a plan along with their counter, and the rejoinder have given a map, because in the counter that map is not clear. They have not given the contour heights in the plan, and the various some errors.
This canal is not some very simple thing like we simply divert a canal. It's not like that.
No, I can understand.
Realignment of a canal is a massive project, sir. It's not such a simple thing.
It's a minor irrigation project. It's
It's called minor irrigation project.
No,
but the project is a project. Yes.
No, we are not telling to align the entire canal, my lords. Lordship may see the map with the rejoinder that I filed. Only 2-3 kilometers, they have to divert the canal.
The word only is very misleading in these kind of contexts, sir. 2 kilometers of a canal is massive, massive.
But they have filed a counter. I filed a rejoinder to it.
Right.
And this is a matter of minutes. We have an engineer in the bar also. If you can be referred to him, he can give his opinion on this.
Why should so? See, we don't, I don't know. Justice Raman, I can't speak for him. I'm not a civil engineer.
No, we are
I'm not an expert in these matters. I don't know how many bars lawyers are expert civil engineers. Maybe Mr. Pal is. Are you an expert civil engineer?
One of the retired engineer, he is practicing that. He referred to
so the other way around.
Yes.
So to become civil engineers is a bit difficult, sir.
No, lawyers are not civil engineers, but civil engineers are lawyers. Or else, this is.
These are not matters where lawyers can sit and decide.
This plan we have given in the rejoinder, the plan.
So you are very well informed, sir. We both have to plead ignorance. Civil engineering matters, they don't give us training as judges in these matters, sir. Very poorly trained in these matters.
Well, this is part of the Kapilas Hill Elephant Sanctuary. Was to be made. Then the sanctuary.
We are totally ignorant, sir. The two of us, incapable of understanding real structural changes.
No, that was the
soil, whatever is the thing, and how water should flow from here to there. Very difficult for two judges.
Well, some way has to be found out.
I know, but not with judges. No, you have to go to the right people.
No, we have gone to the.
If you have some medical problem, you will not go to the engineer, correct?
Well, Lordship may see Annexure 1. Lordship may see Annexure 1 to the petition.
Yes,
the number of news reports and what we are subject
to. Actually, the press is very well informed, sir. They write about everything. They are experts on everything. Judges
they have not given.
Judges are very well informed.
Not on the question of opinion on the engineering part of it, the number of attacks that are taking place.
That is true. See, there are so many problems in society, sir. If you go with all those problems to lawyers will only go to the courts. And lawyers will only go to the judges.
The final arbiter is the court if you can't find a way out anywhere.
For all irrigation problems, also only court has to find solutions.
Supreme Court is sitting on the demonetization issue now. And
see, the problem is what kind of problems you take to a court, correct? Irrigation problem also court.
And this is not only irrigation. Poor villagers suffering.
Everybody's poor. For all of the problems of the poor, if the solution is only the court, then how will the country run?
Final resort is, my lord, the courts what to do.
For which kind of problem, sir? Final resort is not for any and every problem. Tomorrow you may have a pandemic. You will say, no, two judges will prescribe medicines now because court of final resort, poor people, who else will help? Only court will help. Then you will say, you prescribe medicines now. What medicine should be given? Difficult, no? There are limitations. How much a court can do, there's a limitation. Court of last resort is not for these kind of problems. That expression was used in a very different context.
We have no way out now, sir.
No, so if we could give you expert advice on problems of civil engineering, we would be happy to give you.
They did some solar fencing,
we are unable to give you that kind of advice.
They did some solar fencing, electrical fencing, some elephant.
See, you are already an expert. This is
not an expert.
You are an expert. You are able to give solutions.
Is that
but we are not able to give that kind of solutions. Sir.
If an elephant is injured, immediately they arrest and put behind bars.
Right.
Difficult to get bail also.
Right.
Because if some human injury is there, they'll get bail. But elephants, if the animals are injured, we don't get even bail.
Correct.
So these are the problems now.
Yes. Because there are laws governing that, sir.
Well, the gender has been filed, Lordship.
Two very different issues have sought to be combined in one writ petition. One writ petition which is framed as a public interest litigation at the behest of a resident of village/post office Karanji in Cuttack district. So one is regarding realignment of the Rengali right major canal by connecting it to the existing Padabandha minor irrigation project. The direction is sought to opposite parties, that is the Water Resources Department in this regard. Paragraph. As far as this is concerned, the court lacks the necessary expertise or the competence to issue this kind of directions. Full stop. The relief has to be sought elsewhere. Paragraph. The other relief sought is for effective steps to be taken by the opposite parties, open quotation, for protecting the aforesaid villages and areas from elephant attacks and other wild animals and prevent further loss of life and property. Unquote. As far as this prayer is concerned, this court has already seized of similar PILs and does not propose to multiply them. Full stop. Those PILs are being considered by this court on an active basis. Full stop. Consequently, the court is not inclined to entertain the present petition. It is disposed of as such. Right.
11.
Obliged. My lord, in view of the order passed in the last occasion, the matter has been referred to PIL bench, my lord. My lord, matter relating to unauthorized construction over the government land, the villagers are made repents and annexure to, my lord, before the
petitioner's representation, bracket annexure 3, shall be examined by the Tahsildar Bond, and after notice to the petitioner as well as opposite party number 4, and after giving them a hearing, a reasoned order shall be passed. Not later than 10th April 2023, and copy thereof shall be provided to the parties within a week thereafter. The court clarifies it has not expressed anything in the matter.
12.
obliged.
May please your lordships. Because here the petitioners have approved your lordships by way of a PIL. The problem is, minutes, 2 blocks in the Jajpur district. One is Binjarpur, another is Dasrathpur. The drainage system has become obstructed so much way, minutes, about 10,005 hectares of land has become totally unusable for cultivation.
Right.
Personally speaking, I also come within that area. My village comes within that area.
I see.
We are not able to raise any crop because in rainy season it gets flooded. In other seasons also water is not passing. Rabi crops cannot be grown.
Mr. Das, this representation at annexure 1.
Yes, minutes.
Was it delivered to the collector?
Everybody, my lords, I have filed the receipts, my lords.
Where is that?
Everybody, all the opposite parties, I have delivered the representation by way of registered post. I have filed the receipts, my lords.
All right. The petitioner's representation, bracket annexure 1, shall be considered by the collector. Charge board, and after notice to the petitioners, and after giving them a hearing, a reasoned order shall be passed not later than 3rd April 2023, and be made available to the parties within a week thereafter. The court clarifies it is not expressed in the
13.
May I please your lordship, matter is relating to PIL matter. The Puri district of Nimapada area demanded to revenue subdivision since long, my lord. My representation is pending, my lord.
Or it's a petitioner's representation, bracket annexure 3. Where is the proof of submission of that? There is. All right. There are so many representations. You remember the last one? That must be an earlier representation. Which year is that? That is 17 July 21. What is the proof of the last one, sir? 14/10/2020.
My lord, that is the pending also. I am personally meet the principal secretary. Last annexer. 14/10/2022, my lord.
Yeah,
last annexer.
That's addressed to the chief secretary, sir.
My lord.
You handed it over in person to the chief secretary? No, that's difficult to believe, sir. You'll have to submit proof. You'll have to submit proof, sir.
My lord.
So what do you want to do?
My lord, I pray for 1 month time. Today I am submitting the Xerox copy also sent to annexer, last annexer.
No, but there's no proof of that submission of that last annexure, sir.
Oh, party also personally sent in the office.
That's not how it's done, sir.
Earlier, my lord also sent the principal secretary on dated 17/7/2021. Annexer 1, my lord. Annexer 2 also Commissioner of Secretary Revenue Department, Revenue and Disaster Management also 17/7/2021. Acknowledgement is there, my lord.
All right, petitioner's representation back to annexure 1 shall be considered by the Principal Secretary Revenue Department. And after notice to petitioners and giving them a hearing, a reasoned order shall be passed thereon not later than 10th April and communicate to the petitioners within a week thereafter. The court clarifies it is not explicit.
Great hope lies.
14.
Against unauthorized construction over the government land, my lord, the present petitioner approached the opposite party number 2.
Same representation.
Annexure 1.
Dated 1811. Sir, 1811, and when did you file this writ petition?
File number on 5.
You expect miracles from the government?
They have made construction.
18 November, you give a representation.
Day to day.
File on 2nd December.
My lord, day to day, they made construction, more and more construction. Therefore, my lord, urgency.
Where is proof, sir?
Proof, my lord. Thereafter, also on 23rd, again, I am up by this is the receipt, my lord. 18, the villagers, and thereafter, my lord, again on 23rd, another reprint.
See, should you not wait for some time at least? You want all instant results from the government.
Because they made construction day by day, therefore.
It's all right. Some time you have to give, no? Even without waiting for a week, if you start filing petitions, the problem, sir.
Because they made construction.
Wait for some time. Counsel the petitioner seeks leave to withdraw this petition with liberty to approach the government afresh if no action is taken after a while. And after following up on such representation, to seek appropriate remedies in accordance with
Please tell him some tax matters. Item number 15.
Liberty may granted, I will file fresh representation.
May I please, my lords. Yes, this is a matter where sovereign function of the state, my lords, or even the constitutional functions, my lords. My lords, those are the activities which are immune from taxation, my lords. Because here an endeavor is made, my lords, to levy service tax on Campa Fund. Campa Fund, my lords, there's a levy under the one is Soil Conservation Act, and other is NPV, and also, my lords, this afforestation charges, my lords. Compensatory afforestation, my lords. But one is under the Campa Act, and there is a legislation now.
They're not scanned. If I scanned up to page 23, they're not scanned after that. Just make a note of it. 40. Forgotten to scan after page 23. Four also, sir. My page is only up to 23. 25, correct. 25. 25. Oh my God.
Easy.
Yeah, transaction. What you've got is only a demand notice, is it? Show cause and demand notice.
It's a show cause demand notice, my lords. Because here the issue is, my lords,
You've replied to it.
Sorry, my lords.
Have you replied to the notice?
There are two reasons, my lords. One is the limitation, expressive limitation, my lords, statutory limitation, and this is not procedural. This is my lords, mandatory, my lords. So beyond the statutory period of limitation, procedure initiated, number one, limited, my lords, that's the limited issue. And second is, which could not have been taxed, sovereign function. But can a levy, statutory levy, which is under Campa Act, 2016 Act, and NPV under the Soil Conservation Act.
You take all these pleas in your reply, sir. Let's see what order they pass.
Recently, I agree with you. I understand because your lordship in many cases have relegated to approach the, because these are the exceptions. Otherwise, I won't have. Because two recent judgments, 6 days back, there is a judgment to Honorable Apex Court on 2022, on this very question of alternate remedy, that said that your lordship has to maintain self-restraint in exercise of power on 226. Certainly,
we have huge
that
powers.
Your lordship always do.
We always agree with you. We have huge powers. Just some time ago, they said you can even have solutions for irrigation, everything.
My lords.
They think we have powers for everything. So but, we have a lot of powers. But every case we don't use those powers.
100% correct. We fully agree with the lordship's proposition, lords. But the only thing, lords, while your lordship's consents, lords, finds that out and out, lords, certain constitutional activities, lords, sovereign activities are going to be taxed. Suppose lordship being constitutional court, we are getting judicial law dispensing justice service, all citizens, all the people of the country they are getting, lords. Can they under this domain, lords, encroach upon living tax, lords? Because any activity, service with any activity, lords. Therefore, there is a notice, your lordship, kindly see for a moment notification. I have annexed page 83. My lord, it will be very clearer to my lords, my lords. They must not venture to certain uninterrupted uncharted path. 83, Annexure 7. Government of India itself they have to avoid its binding on them, my lords. Subject applicable to service tax. A number of sovereign public activities are agency constituted set up by government perform certain functions, duties which are statutory in nature. These functions are performed in terms of specific responsibility assigned to them under the law in force. For example, the regional reference standard laboratories undertake verification, approval, calibration of weighing and measuring instrument. Regional transport office issues fitness certificate vehicles. Director of boiler inspects issues certificate for boilers. Explosive department inspect issues certificate of petroleum storage tank, LPG CNG tank in terms of provisions of relevant act. Fees are prescribed, is charged, and the same is ultimately deposited government treasury. Like the one here, we deposit the fees below. It's a statutory levy. A doubt has arisen whether such activities provided by the public authority required to be provided under statute can be considered provision of service for the purpose of levy of service tax. Here, service tax levy belongs. 2, the issue has been examined. The board is of the view that the activities performed by sovereign public authority or the provisions of law are in the nature of statutory obligations which are to be fulfilled in accordance with law. The fee collected by them for performing such activities is in the nature of compulsory levy as per provisions of relevant statute, and it is deposited in government treasury. Such activity is purely in public interest, and it is undertaken as mandatory statutory function. They are not in the nature of service in any particular individual for any consideration. Therefore, such an activity performed by sovereign public authority under the provisions of law does not constitute provision of taxable service to a person, and therefore no service tax leviable on such activities. But here, page 63, if your lordship kindly will see, my lords, what is the subject matter of levy? Page 63, my lords, may kindly see per moment, my lords.
Tell me one thing. This show cause of demand notice was dated 11th October 2021.
My lords.
We are in December 2022.
My lords.
What happened in the meanwhile?
Yes, like October, that was issued in October. Only was two months. 1 or 2 months. 1 or 2 months. Yes, that's about a year, my lords. Yes, sir, we have been pursuing, in fact, but they wanted us to.
How can you pursue without filing a reply?
I understand.
I thought they are pursuing you.
I understand, my lords. There is the delay.
They seem to have frozen in their tracks.
But taking into account the gravity of the case, my lords.
No, they forgot to pursue you, sir. 1 year ago, October, they issued notice. October 2021.
But in any case,
and then they went off to sleep. Obviously,
fact remains is pending, my lords. It's pending, but taking into account the gravity of the case, my lords.
How is it gravity? So for 1 year, 2 months, nothing happens. Where's the gravity of the case?
So they lied over the matter. In fact, they also did
so
not.
So you should be very happy. So you have a authority which goes to sleep after issuing show cause notices.
Your lordship, they have slept, in fact, for more than 3 years because they have invoked extended period limitation.
Your luck, you may be in good luck, they may be permanently now Kumbhakarna, they will become. Because of your writ petition, they might now be stirred into action. Otherwise, they would have quietly gone to sleep.
They could have done by invoking normal period. Now they have invoked extension period. 5 years. As your lordship knows, fraud, collusive, coercion, or that misstatement, these are absent, conspicuously. Out and out, one judgment, only 2 lines.
Reserve all that, sir. If they pass an order at that stage when you challenge, all these points were urged. All right. You say the petitioners approached this court at the stage of a show cause come demand notice.
Sorry, just 1 minute. Sorry. I will pray, my lords. Your lordship have held. I have also mentioned Kalinga Ispat Udyog's case. That's where an assessee challenges the question of jurisdiction and limitation. These are taken up as a preliminary issue, and those are to be taken up first before addressing our merit.
You've not even replied. Then how do we ask them to take up?
I will. I am taking your lordship 40 minutes to file a reply.
That we don't know because I think the time for reply and all is long over.
Only I seek liberty in case they decide otherwise. I will approach your lordship. Only that much.
All right.
My lords.
Which was issued to the petitioner way back on 11th October 2021. So from what is stated before this court by Mr. Jagabandhu Sahul and its senior counsel for the petitioner, nothing appears to have happened since then. Admittedly, the petitioner has not even filed a reply to the said show cause notice paragraph. Consequently, the court is not going to interfere at this stage. If any adjudication or any further order is passed by the opposite party bracket authorities on the show cause notice, and if it is adverse to the petitioner, at the time of challenge to such show cause notice, it will be open to the petitioner to urge all the pleas taken in this writ petition and any other plea that the petitioner may have in accordance with law. The petition is accordingly disposed.
16,
May I prefer liberty to approach your lordship in the event, my lord?
Full liberty is always there, sir. Who can stop Mr. Sahu?
My lord, obliged, deep obliged.
Yes.
My lord, in item 16,
Yes.
the petitioner being a registered dealer, your lordships, file the statutory returns, including the annual returns, your lordship, disclosing a taxable turnover of 86 lakhs for the same amount, your lordship, almost identical of 86 lakhs. I have been assessed as an unregistered dealer under section 63 of the Act, GST Act, your lordships.
Well, this order dated 29th September
My lord.
is the adjudication order, right?
Yes, my lord.
It's appealable.
Yes, it is appealable order, my lord.
So what do you want to do?
My lord, I have already filed the return disclosing my taxable
Whatever,
turnover.
sir. Take your statutory remedy.
Try disclose that. I want to bring this notice how the authorities are working, my lord.
My lord, similar order has been passed in the same case.
Yes, my lord. But
Same
return was not filed. This is return filed. It's a case of return filed.
Same
It will make a difference, sir.
My lord.
Same case, same SSA.
They're all taking a chance.
Had no difference, my lord. Returns filed.
My appearance में kindly noted.
Yes, Mr. Chimanka.
Yes, my appearance में kindly also noted.
Of course. Yes. Similar order.
My lord, since they have already recovered 14,96,000, the balance amount to be deemed said it is also to be considered pre-deposit, my lord.
All that. That you can make the prayer there. Same order. All right.
Obliged.
17,
Yeah, order same. You need enough time.
My lord, item number 17, 18, 19, my lord. My learned senior, my lord, in that learned senior, Mr. Tarun Gulati is supposed to appear in this particular matter. His father passed away a few days back, my lord. I'm seeking an adjournment on that basis, my lord. Meanwhile, counter has been filed. Well, we will be filing a rejoinder also.
No, it has not yet been admitted.
Counter?
No,
Where's the
not
counter? Are you in the correct matters?
Yes, my lord. 17, 18, 19.
These are fresh matters. No notice has been issued. So where's the question of who filed a counter?
No, my lord. Inadvertently, Mr. Chimanka has filed an affidavit.
Mr. Chimanka, you are very considerate.
Department is prepared affidavit. It is a preliminary counter affidavit.
See, the department has a very strange policy where no notice is issued, promptly counter is filed, even with the first hearing. When notice is issued, time is taken, no counter is filed.
It is a challenge the so-called notice. Let him appear.
Or counsel for the petitioner is stated to be in some. All three matters, is it? All
three matters.
Well, I am appearing for 3 and 2 and 4.
And I am appearing on behalf of the participant 3 in all cases.
17, 18, 19. 3rd January?
Grateful.
20.
My pleasure, Lordship. But here, due to COVID, my lord, the shop was shut down. And my lord, here, under Annexure 3, government has granted benefits that if there is a shortfall in any quantity and if I have excess, that will be adjusted as interchangeability. At page 15, Annexure 3. But that benefit has not been given and now there has been issued even demand notice under Annexure 5. Lordship, Annex.
Again, the demand is challengeable, no?
That is,
Lordship, and direct the commissioner.
all these,
This letter is addressed to the.
again, they are repeating filing of this. They could have filed the appeal.
No, my lord, I have filed. I have filed a reply before.
You have a package with your clients.
Yes.
Read, then appeal, then read, then revision, then.
But my lord, here it's a COVID matter. They should have given the benefits. We have, without operating the shops, we have paid the license fee and duty, my lord.
That is to be urged before the commissioner. Commissioner.
No, it is the address to the commissioner. It is government letter, annexure 3, page 15. The benefit has been granted to the licensee by the government to the that is to considered by the excise commissioner.
To the commissioners.
No, Lordship, may direct that excise commissioner will decide that.
Yes, ma'am.
Counsel, the petitioner seeks leave to withdraw the present petition with liberty to challenge the impugned demand notice before the excise commissioner in accordance with law.
No, Lordship, refer to the annexure 3 because government letter that is important, Lordship.
That you.
It will be petitioner to urge all the pleas raised in the present petition before the commissioner.
No, item 59 also same.
Same order.
59 same.
Or correct. Disposed of is withdrawn with liberty spread. All right.
21.
My lord, here, my lord, your lordship had sent me to the commissioner. Then he has rejected. I have come again.
That order is revisable under section 6. Again, the same problem with my learned friend. He has to file revision. Then only writ is maintainable.
Table tennis, ping pong.
Yes.
We'll send you back now again to revision.
Mala, 100 of cases your lordship has decided. That is why I have come. Otherwise, I would not have come, my lord. They also admit that the shop was closed. They do not dispute that my shop was not closed.
You know, the more we decide, the more the filing will go up. You saw the Madurai bench. It's some kind of a record they've set up. In Madurai bench of the Madras High Court, this news item has come. The large number of petitions have been disposed of in just 3 months. But they noticed that the filing has then increased manifold.
Yes. But
multiple proceedings will be there.
Exactly. All right. So we will go in a revision now.
Yes, madam. Section 6.
All right. Counsel, the petitioner seeks leave to withdraw this petition with liberty to approach the revisional authority against the impugned demand notices.
No, against the impugned order of the excise.
Impugned order dated 20.
Also the demand. So also the demand. Both have to be there.
That
is the demand and the consequential order dated 29/10/2022. Passed by the excise commissioner in accordance with law. Disposed of is withdrawn with liberty is prayed for. Orders.
For orders. 22.
Well, on 1 week time to remove the defects.
What 1 minute? What's the delay?
165 days.
We leave the question open, sir. There's a delay of 165 days in filing the revision petition, which is not properly explained. Consequently, do not condone. MC 130 of 2008 is dismissed. Nevertheless, the question of law raised is left open for decision in some other case. The revision petition is disposed of. All right.
23.
I may be pardoned, my lords. My lords, Mr. Debashish Panda has been directed to appear for the opposite parties, my lords.
1 minute. Who's for the appellant? Let's see there. Anyone appearing for the appellant?
So far as this case is concerned, I need a copy of this because it relates to some UD department case. That is
who's for the appellant, sir?
Because if the writ appeal copy.
You can only pass it over once. Let's see. We'll pass over. Right.
24.
I plead, your lordship. I pray for 1 week time to remove the defect, your lordship.
The 2015 matters.
Matter was filed against the ex parte judgment against the wife, your lordship, on behalf of the husband, your lordship. Here only the permanent alimony was 1.5 lakhs, your lordship. And as the council missed the list, your lordship, that's why the matter was dismissed. And after filing repeated memo, your lordship, as the matter could not be listed and on being verified, it came to knowledge that the matter was already been dismissed, your lordship.
As it is was delayed, sir. Mata itself was delayed.
That's the ex parte judgment, your lordship.
Sir, we are not delay, sir. Come to the original order of 15th April. That itself was on delay. There was a notice issued in the delay application. All right.
Yes, your lordship.
So which means the matter itself was delayed.
Yes, your lordship.
Then you don't take steps pursuant to that notice.
I already filed the recusals, Your Lordship. On 16/4/15, Your Lordship, I already filed the recusals.
thing is, due to incomplete requests, notice could not issue. That was the noting. So
That order was
this is
passed-
indifference at all levels throughout.
Only one chance, Your Lordship. 1 week, Your Lordship, to remove the defects, Your Lordship.
No, sir, we're not inclined. We
Because
say
the wife
appeal
will
itself
suffer,
was
Your Lordship.
rejected
It's an ex parte judgment, Your Lordship.
due to non-appearance. In fact, the appeal itself, original appeal itself was delayed, and therefore notice was issued in the delay application, condoned delay application on 15th April 2015. Would stop incomplete requisites were filed. To top it all, none appeared, and the matter was listed on 30th July 2015. Consequently, the court is not inclined to entertain the present application. It's dismissed. Right.
15, 25.
In
sorry.
this application, also defects have not been removed for 7 years. Then you say it's dismissed. Right.
25,
None appears dismissed.
26,
None appears dismissed.
26.
Ah,
There are certain
you're better, sir. Yesterday you were unwell.
defects. Thank you very much, sir.
No, no,
Much
please.
better than yesterday and day before.
Okay.
Thank you very much.
No, no, please.
Was 25, Lord. 26, Lord, I've raised for some time to remove the defects. It's a 2015 matter. So most probably this will be standing.
What is it about? What's the tax effect?
Tax effect, Lord, is more than 2 lakhs. I'll just. This particular matter,
13
I
lakhs.
stand covered by a lordship's decision in DK Constructions, my lords.
Show us.
Let's, I've just not got the printout, your lordship, to call it next week. I'll get the printout, my lords. So State of Orissa versus DK Constructions. That's STREV 101 of 2011, where your lordships have held that supply of boulders to the railways and boulders to be minor minerals and taxable at the rate of 4%. Not at 12%. That will be one of the issues in this case. The other issue would be whether transportation charges, which would be excluded.
Issues are covered in that.
Manats, that is also covered by Kiran Store.
100 VST page.
Sorry, Manats?
100 VST page 24.
Manats, that is DK Construction. Manats, where your lordships have held that since these boulders are minor minerals, it was also involving these crushed boulders which are used as ballasts by the Southeastern Railways. There your lordships have held that these ballasts are minerals and chargeable at the rate of 4%.
All right, you just say notice returnable.
Copy has not been. I'll serve the copy. The other defect,
5th April. Defects be removed in the meanwhile. Right. He accepts notice and copies be served. All right.
Lordship have fixed any date?
5th April.
5th April. Obligement.
27.
2 weeks time may be given to remove the defect. I have to obtain and file certified copy of improved
That
order.
was 7 years ago, sir. Defect was pointed out.
Yes, sir. The department has challenged the order of the first appellate authority before the tribunal. And against that tribunal order, the petitioner has filed this revision application with the lordship. So I will obtain the certified copy in the meantime. 2 weeks time may kindly be given. So far as issue in this case is concerned, your lordship, that has been covered by the Honorable Apex Court 2 decision, your lordship. I will address your lordship after removal of defect.
All right, is a notice returnable 5th April. Defects be removed in the meanwhile. He accepts notice. All right.
28.
May I please, your lordship? Annexure 1, eligible copy of Annexure 1 is to be filed, my lord. The demand is more than 3 lakhs.
More than
3 lakhs, my lords. The question of law, my lords, is the setup of purchase tax paid while selling of rice. I have paid purchase tax on paddy, and thereafter I have converted into rice and I have sold. That purchase tax has been denied, my lord. My lords, have similar matters have been admitted by your lordship. I'm placing. 17th April, my lords have posted.
All right. Notice returnable 17th April list along with STRV 57 of 2015. All right.
In the meantime, I will remove the defect.
Defect will be removed in the meanwhile. All right.
29.
None appears dismissed.
30.
1 week time to
Here. I hear my lordship. 29.
You're in 29.
29, yes, my lords. May I apologize? In fact, this is to 2016 matter. I have to perform the first anniversary of my wife in January, for first week of January. I may kindly be granted for 4 weeks time, say up to
At the request
16th of January. I am not in a proper mental position.
10th April. List on 10th April. Defects we removed in the meanwhile. All right.
Yes.
10th April, sir. Right.
Okay, that.
30.
I'm obliged.
My lord, 1 week time to remove the defects.
What is it, sir? Let's see.
This is regarding that brand.
Sorry?
Pardon?
Brand, the out.
This is some other matter, sir. You can disengage.
Okay.
My lord, it is regarding brand. The tribunal held it as tax-free to the state is before your honor, by your lord.
I think this is already covered, no? This wheat brand and all. I think you've decided this wheat brand.
Yes, my lord has decided, but I have not gone through that order.
Falls in the fold of entry 30D. It's covered. Counsel for the state seeks time to examine if the issue raised already stands covered by a judgment of this court. At its request, list on 12th April. Let me examine.
31.
Well, I'm in virtual mode.
Yes.
So 1 week time may be allowed to rectify the defect. Already, my lord, yesterday, STRB 23 and 24 has been allowed, and this is 25, that's a CST demand.
What's the delay?
17 days.
It's only 17.
You're saying that the assessment order is antedated.
My lord, this is antedated. And this is covered by our own High Court, the Delhi Footwear Judgment.
How do you know it's antedated?
That is, kindly have a glance to page that assessment order also there in the order itself. The order dated is 31st/3/2008. That is page 10, annexure 1.
Yes.
And it is issued on 6/6/2009. So in the itself in the order here mentioned that.
All right. One of the allegations in the petition is that the assessment order was antedated. Although the printed date is 31st March 2008, the handwritten issue date reads as 6/6/2009. You say notice, he accepts notice. The original assessment record we produced before the court on the next date for perusal.
Along with STRV 23 and 24.
List along with STRV 23 and 24 of 2016 on.
The date has not been given, my lord.
Okay.
Yesterday's, that was the
Yesterday's list, if you see. Oh,
Only related to rectify defect, my lord.
Or this, along with those two, on 11th April, defects be cured in the
Obliged.
32.
If my lord, your lordship permit, I'm here from item number 32. Your lordship, a limitation petition has to be filed by us and certain defects has been pointed out in this matter. If your lordship could permit us some time, we would rectify all the defects arised in this matter and also we would submit a limitation petition within that period.
What is the issue raised, sir? All right.
So this is a
all right.
prima facie case. We are not satisfied with the
notice returnable 17th April. He accepts notice. Defects be cured in the meanwhile. All right.
33.
Unappeased dismissed.
34.
34, my lord, states revision. The question of law is at page 18.
What's the tax effect?
Tax effect is 1,40,000, man. It's penalty 9C5, which is parameter area with 40 to 5 of the OVAC Act, my lord. Same question has already been.
All right. What's the is there any delay? No. The dispensing with that is allowed. The notice returnable 24th April.
$35.
35 is also, my lord, states revision. The question of law is that is 18 of the revision petition, my lord. The question is whether on the facts and in the circumstances of the case, the tribunal is not justified in reversing the order of the first appellate authority and deleting the penalty imposed in exercise of power under section 10, subsection 2 of the Odisha Entry Tax Act 99 by the assessing authority for failure to discharge the tax liability by the dealer opposite party. My lord, this is also similar to 43.2, where my lord has passed a review petition. My lord has held that it's a discretion of the assessing authority.
Correct.
Here the assessing authority has imposed penalty. But first appellate authority confirmed it, but the tribunal has deleted it.
Yeah. So what's wrong?
So that is against you.
Yeah, that's right. Correct. Correct. You say the short question raised by the revenue in the present revision petition concerns levy of deletion of the penalty imposed. Deletion by the tribunal of the penalty imposed on the SSC by the assessing authority under section 10 bracket 2 of the Orissa Entry Tax Act 1999. Full stop. This court has a National Aluminium Company Limited versus Deputy Commissioner of Commercial Taxes, 2012, 56 BST 68 bracket ORA bracket, held that the power of imposing penalty under section bracket 10 bracket 2 of the OVAT Act, OET Act, is a discretionary one. Full stop. Correct. All right. Yeah. The aforementioned decision was reviewed by this court judgment in Nalco versus Deputy Commissioner of Sales Tax. Give the citation 2021. Yeah. Consequently, the court does not find it necessary to interfere with the impugned order of the tribunal. And no substantial question of law arises as urged by the state. The petition is accordingly dismissed.
36.
My lords, 36, tax effect is 7 lakhs, my lords. The grounds, my lords, at page 6. A, my lords, whether the division bench of the tribunal is justified by rejecting the grounds of and submission of the petition regarding to allow the exemption of sales to Nepal. My lords, there is a specific notification by the state government that any sales to Nepal is exempted. And my lords, what the learned tribunal has said, Form H is required. My lords, for the exporter, Form is required. It is required for the penultimate seller, my lords. Kindly see Section 5(1). I come under Section 5(1).
All right, notice returnable 24th April. He accepts notice. All right.
37.
Defects be removed in the meanwhile.
No.
37.
None of it is dismissed.
38.
None of it is dismissed.
39.
39 is, my lord. The question of law is at page 11.
This MC 71 of 17 is allowed. 42.5.
Yes, my lord.
All right. Notice returnable 24th April. All right.
40.
None of it is dismissed.
41.
41, my lordship. I pray 1 week time to remove the defects, my lord.
Entry tax on sales turnover of bitumen and furnace oil. There's no judgment,
copy, my lord.
No judgment covering this. All right, we say notice returnable 24th April. He accepts notice. Defects be removed in the meanwhile. Mm-hmm.
42.
42, my lord, some time may kindly be granted for
What's the matter about, sir? Tell us.
Lost the file, my lord. 1 week time may kindly be granted.
Non-service of statutory notice. Tax and penalty due is 53,000, sir.
23,000.
53,000.
Not placement.
You see, in view of the insignificant tax effect, the court is not inclined to interfere. Leaving the question of law open, the petition is disposed of.
43.
Small amount, my lord.
Yes.
Similar order may pass.
Similar. All right.
44.
44, my lord, covered matter. Taxation on meter rent already given the other. 40.
Have you supplied the copy?
Item 44 already covered matter in tax revision 70 of 2004. Taxation on installation of a meter rent.
Yeah, in view of the decision dated 10th April 2019 of this court in STREV 70 of 2004, the present revision petition is dismissed. All right. Oh, no, it's an executive engineer, no? So, in favor. No, but there it says it's dismissed. Show me the judgment. Executive engineer. Oh, are interfered with and set aside. I see. The impugned assessment orders are set aside. All right. The revision petition is just
45.
Same matter, man, that
RERA. All right. We'll take it up with that RERA matter. All right. Pass over.
46.
46, there's some defect pointed out. It's not taken off 1 week after. Remove the defect in the meantime.
Copy maybe, sir. Comment state
State
you serve copy.
Copy solve already, sir.
The same representation.
Second journey of the petitioner, because the Adarsh Vidyalaya has been also announced by the state government to set up in different places. That is one of the places that the state this authority, they are also changing because on political.
Removed within a week. List thereafter. All right.
47.
Obliged.
Villagers of the Alarpur village has encroached the irrigation department lands, which are either river embankment or canal embankment or drains. That earlier
the petitioner's representation.
Petitioner has approached this honorable court in a writ petition, basing on which the notices are issued by the Tahsildar Cuttack. But after the disposal of the case, no action was taken by the collector.
Petitioner's representation bracket 5 be examined by the collector Cuttack and after notice.
The Tahsildar Cuttack is
all right. You want to hear it?
That is Annexure 5. Representation is pending with the Tahsildar
Your lordship
Cuttack.
has rightly directed the collector to consider.
Yeah, collector. Yeah. And after hearing the petitioner, his order shall be passed not later than 10th April and be communicated to the petitioners within a week thereafter. The court clarifies it is not expressed in the court.
48.
May I please, Your Lordship? This is a PIL, my lord, filed by a responsible citizen and a member of bar also for implementation of the provisions of Sexual Harassment of Women's Act, Sexual Harassment of Women at Workplace Act 2013, my lord. That is only by specifically the prayer has been made with regard to section 19B, which speaks of that all the institutions, including hospitals, temples, everywhere, that one in a conspicuous place, one board should.
Of Women at Workplace Act.
A display board should be there where it should be mentioned that here the penal provisions are there and here for sexual harassment some punishments are to be given. And the toll-free number, a toll-free number also in some institutions, as I know, some companies also, but because the act was passed in the year 2013 only as per the only direction of this Honorable Apex Court only, and it took long run, my lord. 79, although the India was a signatory to that, it took the India ratified it 1993. Then only as per your lordship's Visakha guideline only the law could be passed. Then the law could not be passed for 15 years, that is 2013. And after getting instruction that when the Apex Court took it very serious view in 2012.
All right, notice.
And
50%
of the
1 and 2 and Mr. Party for opposite party number 3. All right. 3 and 4. Since the petition seeks implementation of section 19 bracket
B,
small b of the Sexual Harassment of Women at Workplace bracket Prevention, Prohibition and Redressal bracket Act 2013. Affidavits be filed by the opposite parties, respective opposite parties, informing the court of the status of compliance with the said requirement. The said affidavits be filed at least 1 week prior to the next date with an advance copy to consider the petitioner. List on 10th April. All right.
49.
May I please your lordship, my lord. This is a PIL, my lord. I have filed this PIL on the ground that Tulasipur Hattigoda Basti, my lord, is an old basti. Now the Cuttack Municipality Corporation has disconnected the water connection that is on 27, my lord, 27/11/2022, my lord, at 4 a.m. They, without giving any prior notice, he disconnected the water connection, by which the family members of the Tulasipur Hattigoda Basti is facing lot of trouble, my lord.
This Mr. Nayak is not appearing at all.
No, my lord, I am appearing on behalf of Devashish Nayak, my lord. My lord, I have received the copy on 5th, my lord. Allow one list this matter on Monday. I will take instruction, my lord. Yes.
My lord,
Without water, how long can they survive, sir?
My lord, from the
We'll list it tomorrow. You better find out.
Day after tomorrow.
He's been chasing you people for even serving a copy.
No,
Last 2 days, I've been asking him. He's been saying, "No, I've served copy. I've served copy." None of you is appearing.
Receive on 5th, my lord. Day after tomorrow, I will take instruction.
You see, the petitioners complain of sudden disconnection. The families of Tulsipur, Hattigada, Basti have the present petition complained of sudden disconnection of water supply. We'll stop. In view of the dire situation in which the petitioners are placed, the court will be informed by the Commissioner, Cuttack Municipal Corporation, bracket opposite part number 2, of the steps taken to alleviate the distress of the petitioners. We'll stop. List on Friday, day after tomorrow.
Bless me.
Is that really about?
50.
Well, let's item 50. There's some defects. The first
defects be removed within a week, list thereafter. All right.
51.
May I please, your lordship? Sir, in this case, I have challenged the 148 notice at page 17 under annexure 1. The assessment year under consideration is assessment year 13-14, and the date of issuance of this notice is 30/3/2021. This is covered matter.
All right. In view of the decision of this court dated 24 January 2022.
Poonam Agrawal, Judge, WBC number 22678.
Give the judgment of this court dated 24 January 2022 in writ petition civil 20919 of 2021 and batch bracket Messrs. Ambika Iron and Steel Private Limited versus Principal Commissioner of Income Tax bracket and the judgment of the Supreme Court in Union of India versus Ashish Agarwal 444 ITR 1 bracket SC. The impugn notice dated 30th March 2021 issued under section 148 of the Income Tax Act 1961 for the assessment year 2013-14 hereby quashed. The writ petition is disposed of.
It's a consequential order.
And all consequential orders.
Published.
52. Around 52.
Pass over.
53.
Pass over.
54.
Lord,
May I
item
please, your
54.
This is the application.
My lord, item 54, my lord, I may be permitted to, my lord, remove the defect within.
All right, defects be removed within week, list thereafter. All right.
55.
May I please, your lords. The petition and this writ petition has challenged the action of the authority, it is annexure to notice 148 and who was issued in subsequently placed annexure 3
Defect
on
is there.
1/4/2022.
Defect. You received a copy.
Defect the copy also I have served the copy.
You got a copy. Ah.
So it is for the assessment of 1415 Mailer.
Hmm.
The annexure 2 and annexure 3 that notice has issued on 1/3/14/2022.
Covered, same thing.
It is not like that, yes, my lord. It is the covered decision of the another High Court, that is Allahabad High Court and Chennai High Court, my lord. Keeping the copies, my lord.
My lord, I have to take instruction.
On very similar issue, they have caused the notice. As it has been issued on 1/4/2022, which is after the 6 years.
What are you challenging here?
You are challenging 148 notice that is issued on dated 31st March 2021, and the notice has been served on me on 1/4/2022 as per their signature.
So let him take instructions. According to the petitioner, the notice dated 31st March 2021 was served on the petitioner only on
1/4/2021.
1/4/21. You said 22 just now.
No, 1/4/2021.
On 1/4/2021, Mr. Chimanka seeks time for instructions. List on
No course of action.
1st February. No course of action be taken against the. Wow, but this is a 2021. What course of action will be there? Nothing. Just say notice. No need for an report. Just say notice.
We have previously filed the writ petition, so we don't.
Nothing. So such you have come so late.
I have previously writ petition and annexure 5, my lord. Thereafter, I have.
It's all right. Yes.
56.
May I please, Your Lordship? Your Lordships, and for 56, 57, and 58, Your Lordship is permitted to withdraw.
All right. Dismisses withdraw. All right.
Your Lordship's liberty may be granted when it
All right.
cause of
Liberty
action.
to file a fresh petition when any cause of action selects. All right.
Oblige, Your Lordship.
Over, please.
60.
I may be allowed to submit from DC, my lord. 60 items.
59 is the
59 is over. Same as
Same.
that.
I am sorry.
Item 60.
My lord, I may be allowed to submit from DC. Item.
Yes.
My lord, order dated 11/8/2022 may be seen, my lord.
Yes.
This is for admission matter, and we have already served the notice to, served the copy to the council, revenue council, matter, income tax council.
Sir, are you interested in arguing or you don't want to argue the matter?
My lord, I am interested. My lord, this is a case where the purchases of the assessee were doubted. Therefore, they issued the 133 notices to the suppliers, and the suppliers sent the replies, which is in page number 57 to 63. Annexure 5, my lord.
Well, Lordship, the addition made notice in 69. The appellate authority reduced to, after examining the document which are filed before the appellate authority, reduced to 23,77,750. And the tribunal has considered everything, Lord, and your Lordship see the order of the tribunal. It is a totally factual issue, Lord. He has not produced any evidence to that effect. Whatever document is produced with the first appellate authority, he has reduced that amount. deletion made, my lord, 39 lakhs 13,566, and the appellate authority reduced to 23,77,750. Now he was before the tribunal. Tribunal has not considered these issues, my lord. Then he filed an application to rectification defect. That also dismissed because there is no, the order says not that is not a defect apparent in the face of the record. That also dismissed.
My lord, this is not the case.
Therefore, this is not a substantial question now involved in this case.
My lord, this is not the case. Actually, Annexure 5 may be seen, my lord. The notice is sent to these suppliers, and the suppliers had given the replies on 6th April 2015. Whereas they should have got the assessing officer should have considered it, but before getting the notices, he has passed the order on a date that is 27/3/2015, and before the commissioner appeal, he did not mention that these are the documents they received and they should not have doubted the business. And even before the tribunal 2 times also, they did not submit these details before the tribunal and suppressed. And the tribunal also, because of the suppression, the business is doubted, and the cash sales, whatever deposited in his bank account, were treated as if income from undisclosed sources. So this is a case. They had the documents, that is Annexure 5, but they did not submit or did not use it. Annexure 5, I request to Revenue Council to see that Annexure 5 itself.
Yes.
Mr. Revenue Council is not ignoring the Annexure 5. That is what the issue is, my lord.
But too many questions you have framed, sir.
Any one or two is 49, page 4.5 paragraph.
You have framed 7 questions.
My lord.
Can't have all these questions, sir. I think question 2 is enough.
My lord, 1 and 2, and 1 and 2, then.
No, that's suppressing and all. We can't frame a question about suppressing, sir.
My lord. The point is whether the suppression is allowed for the department, because they are the statutory authorities.
No, you can say, is the order valid? You can't say, were they justified in suppressing? How can a question of law be framed like that?
My lord, my inefficiency, my lord.
It's only about interbranch transfers, sir, that's all.
And my lord, actually, not interbranch transfer. He was getting the cash sales from the customers by getting the money in their areas. He was.
Sir, these questions of law have not been properly framed. They're all like grounds. They're not questions of law.
My lord, question of law is that whether on the facts of the surplus, whether the assessing officer legally justified in suppressing and not producing the replies.
That's what. How can this is like a ground? This is not a question of law. Every question like this you have framed. It's argumentative. It is like a ground. It's not a question of law.
My lord, actually,
no court can frame these kind of questions. You frame the question, sir. Answer the appellant seeks to properly frame the questions of law that he wishes to urge, and file a suitable amendment application for that purpose. List on 24th April.
Item 61, my lordship, can I have a glance to order dated 7th of September.
My lord,
I was directed for the counsel for the petition.
My lord, I am not the petitioner. I was directed to file an affidavit whether the land, government land, is available in the village for expansion of the high school or not. My lord, I have ascertained that there is a, my lord, land My lord, I will file affidavit within 2 weeks, my lord.
The petitioner states that he'll file an affidavit in terms of the order dated 7th September 2022 within 2 weeks. List on 4th April.
62.
62, Your Lordships. We are filing a small note. Small. Yeah, we've gone through those videos, Your Lordships, and photographs. Your Lordships, our first impression is, of course, Baleswar, it has to be lauded for a lot of things. Your Lordships, in that video, they are making these local towels, which are called gamcha, and which has got a good market. So that's really picking up. Even the mushroom farming we saw is really picking up. In fact, the Baleswar collector himself was there and making of this compost. So, Your Lordships, our first recommendation would be these things can really be implemented everywhere and it will really work. They have got good market for all this.
All right.
Your Lordships, and we find that in Puri, Your Lordships, if Your Lordships remember that the first order was for Sanjay leprosy colony, which is on the railway. The entire photographs and everything is of the colony which is near the temple, which was run by the Christian missionary, where everything is more or less disciplined. But there is nothing, no reporting, nothing about it. And where people really need the toilets and everything. So there is literally no follow-up there. Your Lordships, and even in Jajpur also, we find that these photographs, Your Lordships, will find that the good places of the colony is highlighted and the rest of the colony we don't get a feel. But the entire purpose is to know what the problems are. Your Lordships, even the housing facility needs of Mayurbhanj, Your Lordships, we've made that Saraswati colony in district of Mayurbhanj, where people are saying we found most of them are thatched roofs, Your Lordships. Baleswar, Your Lordships, we found that the work is going on, but I think it needs to speed up a bit. But Baleswar is really working. I mean, there's no doubt about it. And Your Lordships, as far as Puri is concerned, they still haven't come up to expedite that whole thing of relocating that colony. It's on the railways. And in fact, station is going to be expanded. There's no doubt about it, given the... Your Lordships, also see if this note is read with this affidavit that is dated 11/2022, I think that's flag 41. They've annexed the copy of the minutes. That is by one Dr. Ajit Kumar Mahant. You'll also look at the minutes. In the minutes, at point number E, this is what they had decided to do.
Housing and urban development.
Yes, Your Lordships. By the end of December, I mean, if they really have done something, then this, I think they can put what exactly they have done and how they have proceeded in this matter.
Well, in fact, this aspect is being monitored by the monitoring committee. So let's direct the monitoring committee to hold a meeting within a few days so that the committee can take up all these issues.
No, not a meeting. I mean, this is a decision long back. They can give the compliance to the court.
Implement it.
Yes.
The compliance to the court.
All right. The convenience note has been filed by the amicus curiae, in which the following issues have been highlighted. 1, the photos and videos placed on record with the affidavit dated 14th November 2022 of the Commissioner cum Secretary to the Government, SS and EPD Department, Odisha, does not disclose the follow-up on the skill development programs in the districts of Bargarh, Cuttack, Jajpur, Puri and Sundargarh. 2, while the training imparted to inmates in the Louis leprosy colony at Baleshwar in making of towels, mushroom farming, and making of composts are duly reflected in the videos, the colonies in the districts of Bargarh, Cuttack, Jajpur, Puri and Sundargarh should adopt the above practices for their respective inmates on an urgent basis. 3. The Sanjay leprosy colony in Puri does not appear to have been visited at all. Full stop. No relocate the inmates in the leprosy colonies of Puri appear to have been taken. Next. Only portions of the colony in Jajpur have been reflected in the videos / photos. Full stop. The entire colony is not covered. Then next. The houses in the Saraswati colony in Mayurbhanj, where the inmates are staying, require a regular roof and their housing facility must be improved. Last, you say construction of 20 houses in Baleshwar has not yet been completed. And directions are required in that regard as well. Paragraph. It also appears that certain decisions were taken at the third meeting of the monitoring committee held on 15th October 2022, which have been enclosed with an affidavit filed by the Commissioner on 10th November 2022. Full stop. One of these decisions was that, open quotation, the Housing and Urban Development Department will provide basic amenities in 12 colonies located in urban areas by the end of December 2022. Stop. In case of the colony in Bargarh district, which is located in rural area, PR department will provide the amenities. Unquote. Paragraph. The learned AC point out that despite the above decision of the monitoring committee, effective steps do not appear to have been taken for provision of basic amenities in 12 colonies in the urban areas. Yet. It is also not clear whether the amenities have been provided in the colony in Bargarh district as decided at the above meeting. Paragraph. The code, it's the state government and in particular the Commissioner cum Secretary SSN EPD Department, Orissa, to file an affidavit on all of the above aspects as pointed out by the amicus curiae. Full stop. The necessary corrective steps and steps for implementing the decision of the monitoring committee should be taken forthwith, and the affidavit should that each of the above issues highlighted have been properly addressed. Full stop. The affidavit will be positively be filed on or before 8th February 2023. List on.
My lord, I have small prayer in this case, my lord. I am for the intervener, my lord. Today I am filing one affidavit regarding reply of.
Well, so far as that IA is concerned, my learned friend is trying to expand the scope of this PIL. Well, here, my lord has taken up this matter for rehabilitation of the cured leprosy patients. Well, now he is expanding so far as appointment and filling up. He can file a separate petition.
No, filling up of what?
Filling up the posts of multi-purpose health workers.
That's connected with this only, sir. Why have a separate petition? In fact, the amicus curiae have been pointing this out. Yes, that those posts are remaining vacant, the multi-purpose health worker posts.
No, that we have filed the affidavit indicating what is the strength as on date.
So what is the state of filling up?
You lordship may kindly see. In fact, we have filed the affidavit of the health department that is available at flag 31, my lord may kindly see.
Where is your affidavit, madam?
My lord.
Kindly.
Even the 45.
31. My affidavit at flag 31, my lord, you can say that is affidavit dated 1/8/2022.
Yes.
Flag 31, that is the affidavit.
Yes, sir.
Paragraph 4. After integration of NLEP program with the general healthcare system, the posts of paramedical worker have been abolished by government order number so-and-so, which was informed to the SSCPD department by letter number so-and-so. At present, the leprosy work is being carried out by the general healthcare staff like medical officers, IUs, medical officers, physiotherapists, multipurpose health worker, as is implemented for the. Now, on the basis of this this paragraph 4, last occasion, my lord directed to come up with the detailed affidavit. Now, also file the detailed affidavit that is available at flag 45 by the health department. Flag 45, that is affidavit dated 2/12. Flag 45, man.
Yeah, same affidavit. 212.
No, flag 45 is the recent affidavit.
Yes.
That, my lord, may kindly say, internal page 2, paragraph 3, that it is humbly submitted that the multipurpose health worker, male and female, are available for follow-up and care of persons affected with leprosy under National Leprosy Eradication Program, in addition to other programs under general healthcare system. That it is humbly submitted that in addition to 10,920 numbers of multipurpose health workers, now there we have given the the number of male and the number of female workers. Other paramedical staff numbering 55,200 to 262 numbers also involved in case detection, follow-up and care, namely so-and-so, then paragraph 5, that it is submitted that different manpower such as 66,182 working for National Leprosy Eradication Program activities are also involved in active case detection and regular surveillance. They have given all those details.
No, but in this context, when you say it's abolished, and now in para 4, you say that in addition to 10,920 numbers of MPHW, other paramedical staff numbering 55,262 are also involved. So this multi-purpose health workers are still working.
The paramedical workers have been
Lordship, these are, my lord, for the general healthcare services, multi-purpose healthcare workers are there, my lord. Therefore, the male, female, ASA is also there.
No, but for what about leprosy paramedical?
Yes, that is what your lordship had asked for, my lord.
We need that information, sir. Because you need specialized trained people.
No, last order, my lord, you can see paragraph 4. My lord, directed to file a further appeal disclosing the number of
available for training purposes affected with leprosy. This is generally available.
Yes.
So we wanted specific for persons affected by leprosy. What is the care for them? I mean, how many MPHWs are available exclusively for that purpose?
For case for treatment.
That's what we'd asked in para 4.
Yes.
Disclosing the number of MPHWs available for treating persons affected with leprosy.
This is affected with. Yes. I will come up with a further affidavit.
Although an affidavit dated 2nd December 2022 has been filed, inter alia stating that 10920 health workers bracket MPHWs and paramedical staff numbering 55262 open quotation are also involved in case detection, follow-up, care, etc. Quote. It is not clear whether these MPHWs are open quotation available for treating persons affected with leprosy, unquote, as indicated in para 4 of the court's order dated 14 November 2022. Paragraph. An affidavit has been tendered by the intervener in court, where again it is pointed out that despite sanction of funds by the Government of India, for the purposes of engaging trained paramedical workers in 22 high endemic districts of Orissa, the funds appear to have been diverted for other purposes. Paragraph. Mr. Mudali states that a further affidavit will be filed specifically dealing with the issue of availability of trained medical staff as well as paramedical workers for providing care and treatment to persons affected by leprosy. Stop the details regarding utilization of the funds sanctioned by the Government of India from financial year 2013-14 onwards for the purposes of providing the above care and treatment as well as training, be also indicated in the said affidavit. When is that monitoring committee meeting next? Another meeting of the monitoring committee shall be held in the month of January 2023, where the above issue will be specifically addressed. Stop. The minutes of the meeting be placed before the court before the next date. Give me the PI list. February. List on 13th February. Grateful man.
Let's petition file this published litigation Millers challenging the action of the opposite parties Millers illegally filling the village funds Millers, which is status of his Jolasha Millers. Annexure 1 is the RR Millers, that is Millers page 19 annexure 2. The plot number 1 and
no, we'd ask you to find the current status of the building.
Millers, they have admitted that there is a filling up the in counter affidavit. They have admitted that they are filling up the some portion of the Jolasha Millers. Your Lordship, find out that page 29. On page 29 of their counter, paragraph 9.
Sir, after that, this is a counter filed in October 2020. Last hearing had asked you to find out the current status of the building.
Thereafter, there is a status quo. So, status quo order is there since 2020.
No, status quo order, sir. I wanted to know the current status of the building in question.
Yes, your Lordship has directed both parties, but I have asked the concerned officer to provide the instruction. I have not obtained the instruction.
Or if more time is sought for informing the court on the current status of the building in question.
One decimal of land is
No,
They are
not 1 decimal different plot. Millards,
This is for
one
the
acre
public
and-
interest. For 1 decimal of land in.
No, Millards, 1 decimal is the another plot, Millards. I have a 1 acres and.
What I suggest, my lords, the work is stopped for last 2 years because of the order. So Lordship may direct the collector to take a decision after consulting all stakeholders, villagers, and if something can be done, because 1 decimal land is concerned, the 3 lakhs rupees project for the benefit of the poor people of the village. They are also beneficiary. There must be some rival groups between
1
villages.
decimal is another plot, Millards. I have feeling of 1 acre something.
That is my suggestion. If your lordship will say that another date will be fixed to obtain the instruction, I can get.
Yeah, we'll know. You need to know what is happening. Otherwise, no decision is taken on the ground.
Right.
No,
Right.
but fact remains for last 2 years, it is status quo is operating.
No, but
By that date, what was the construction? Extent of construction?
Some photographs, something show us what has happened actually on the ground.
He was also directed to get the photograph.
Yes.
Petitioner was also directed by this honorable in the last order.
Correct.
To provide.
I'll take time.
27th February.
And also
27th
direct the state
February.
government to also intimate that. Direct to the Lawrence, senior Millers intimate the status of.
Either way, sir, we want both of you can inform us. No problem.
Entry order is there. Entry order is there.
Anyway, nothing is happening. Looks like
That is
there
continuing
anything
for last 2 years. A small work of 3 lakhs rupees only.
If entry order is not continued, they have started construction again. Miller.
Will they? I don't know.
Yes, Millers. Trying.
Is there any contempt to that violation you have filed?
I have not filed, but status quo is there. That's why they are not. Only 4 pillars installed in there. Miller. So
Let's see what happens. Nothing happens. 27th February.
Next. 65, my lords. Your lordship has directed to provide the sketch copy of that year. In the meanwhile, what has happened, my lord, the collector Jajpur has transmitted the file to the RDC office for approval. So we have to get this from the RDC office. Another short date may be fixed to file the sketch map because we have to get it from the RDC.
The request of Mr. Manfi.
For compliance of the last order, I need only
comply with
2
the
weeks
order
time.
dated 27 September 2022. List on 18 January.
Go bless. 66.
66, my lord, I'm in DC for the petitioner, but I received the counter on the Friday only. I pray for 1 week time to file rejoinder.
All right. Rejoinder will be filed for the next date. 27th April.
My lord, 67.
Your Lordship, I am for the petitioner. I am appearing through VC in item number 67. On the last date, the counsel for the opposite part number 3 had sought time to file a reply in this matter, but we have received no reply. Your Lordship.
67, we have filed.
You filed the reply. You have to have a copy, sir.
Because union had to file.
Opposite part number.
You have not filed.
Because we have filed, Millers. We have
Your affidavit also, you're not served on the other side, looks like. You say the affidavit of the state be served on counsel of the petitioner, full stop. The affidavit of the Union of India possibly be filed within 4 weeks. Full stop. Rejoinder to both affidavits is permitted to be filed before the next date.
April. 68. The original writ petition was 16813. Thereafter, another writ petition was filed and by the same petitioner for the same on-sop.
First, there we have filed that there is non-compliance of 27 of the Excise Act because it is in the schedule area. I mean, not petitioner is the Sarpanch. They have not taken the prior approval of the concerned Gram Panchayat. And Commission has reported that there is a resolution of the Gram Panchayat. Even then, Milord, government has, by relaxing Rule 26, they have granted it. They have not considered about the Section 27. Section 27 clearly says that there is no license shall be granted.
Lord, let me say what I beg to submit, Lord. So far as the other one is concerned,
other one, Lord, they have for this year, they have not issued public notice, even then. Without issuing the public notice, they have
So,
granted the
anyway,
land.
Not filed your reply.
Yes, we'll file reply.
In first case, they have
cases.
filed reply, but in second case, they have not filed reply.
First case, they filed a reply
Yes, my lord.
Yes.
in 24738.
No.
16813. Not 16.
That's what.
That is connected. 16813.
Correct.
First
that,
one, that
that
is.
they filed.
In that case, he may file a rejoinder. And this second case,
16813 rejoinder be filed for the next date. In 24738, reply be filed as a last chance within 4 weeks, rejoinder for the next date.
Lords, you may fix a sort date because excise year will be
it is
on the
running sub.
31st March. Running sub, how can you allow? Violation of law you are allowing. And every day, my lord, there is objection and the public are sitting in front of the subs. Even then they are allowing the subs. Every day, there is photographs.
That is a very common thing.
Why? Common thing. The Sarpanch is not approving without approval. How can you open a shop?
Internal rivalry between these business groups.
End of January.
My lord.
1st February.
In this case, I am appearing for the opinion number 5, counter not filed, madam.
What about 1st February?
1st February.
Okay.
69.
69 may be taken off some other day, my lord. I am concerned.
At the request of counsel petitioner. 26th April. Both matters.
Obliged.
70.
Item number 70, my name may be deleted, may not.
In this case, my lord, I have
All right. Name of Mr. Mishra be deleted from the area of parties.
I have instruction to appear, my lord. Today morning I received the brief, my lord. I have some breathing time, my lord. Next week, my lord.
At the request of Mrs. Wonso, counsel now appearing for the petitioners. List on 26th April.
71.
71, I pray for next week, my lord.
Every order is there. 70.
Why do you want adjournment in 71?
Actually, the file is not with me. The BBC is fever.
No, your registration itself has been cancelled.
No, but it's unregistered dealer. I don't know what exactly that's that. I don't know that. I have not gone through that.
At the request of counsel petitioner, who needs some time to enter his arguments. List on 20th April, interim audit category.
72.
Infructuous now.
Dismissed as infructuous.
73.
This is another case, my lords. Yes, these are all service contracts in respect of which, lords, I have prayed for issuance of no deduction certificate, lords. That was granted by the sales tax officer, allowing 95% deduction. I wanted 100%, 95%. Then I filed revision. Then it is reduced to 30%. My humble submission is, this was a matter pertaining to 2016. In the meantime, probably this may not. Only I seek your lordships to withdraw. If any further cause survives, I may be granted liberty to reapproach your lordship.
Mr. Sao seeks to withdraw all these three.
No, only 73. Item 73 only.
Item 73. Withdraw the petition with liberty to file a fresh petition if any cause of action survives. This post of is withdrawn with liberty is prayed for.
74.
My lord, we will file a counter, my lord.
So this has already been disposed of by your lordship. The covered matter, I will not. What has happened? Your lordship, kindly see the prayer, what I have prayed for and what my lord. My lordship, kindly see the prayer. This 16/11/2016 circular, my lordship. This is issued by the commissioner, and this has been quashed by a bench of this Honorable Court. Twice it has been once quashed and again reaffirmed. I am giving to your lordship copy of the order. So what has happened? Initially,
in the audit bills, if any demand is raised and penalty is proposed to be levied, if I pay the entire tax along with 25% penalty, the proceeding will abate. It will close there and there. Now has come, which your lordship held that this is liability cost, because you can't make a dichotomy between period prior to and after 1/10/2015. So based on that only, now this is also telltale. If your lordship will see Annexure 1, notice was initially issued for audit for period up to 31/3/2016. Then they restricted the period up to 1/10/2015, which your lordship said relying upon this, no, this will not stand. So in terms of this, now Annexure 9 will go. Your lordship have also consequence orders, your lordship have passed also. That is my case. Now these doesn't survive.
Counter, my lord.
It's covered, sir.
My lord.
Twice, not once, twice.
Mr. Sahu points out that the issue raised in the present petition stands covered by the orders dated 18/12/2019 of this court in principle 4685/2017. And 4/12/2018.
Your lordship kindly mention, I have already complied your lordship's order.
Civil 11988/2018. Full stop.
I have already paid the entire tax and 28% penalty by complying with lordship's order.
Mr. Sahu states that in compliance with the orders passed by this court, the entire tax amount.
Entire tax, yes, amount is here. Your lordship also mentioned the amount.
Not necessarily, not necessarily.
25% of
8/2/2018.
No, we don't want to mention all that.
It is mentioned.
No, we are not going to mention all that. Entire tax amount and penalty.
And penalty, 25% penalty.
And 25% penalty.
As per order 8/2/2018.
All right. Counsel, the department seeks time for instructions.
Minus.
List on.
Progress.
27 mark.
75.
So on this matter, these are customs matters because notice has been issued to two one to the agent and also the principal. Because counter has not been filed. My lords are specifically directed.
My lord, may grant a short time.
The 2017 matter.
No, I've already got the instruction. Any that
Maybe a week. 75. Two matters are connected.
The last opportunity to the department to file its reply within 4 weeks to order for the next day. Interim order to continue.
My lords, obliged.
List on. Fifth April. Obliged.
76. 26, my lord. Entry tax interest matter coming on 16th.
16th of?
Entry tax interest matter coming on 16th of this month.
All right, list on 16th.
77.
Yes, sir. In this case, what has happened by Annexure 5 minutes, both the orders, I have challenged order under VAT Act minutes, alongside VAT OST Act minutes, alongside OST also CST order is set aside. So against the set aside assessment, I approached your lordship. They have invoked 49(2). My lords have relegated me to approach the appellate authority. But here I have to take instruction what happened in the meantime because this is central subject matter. I have.
It's time for instructions on the current status of the matter. List on. Okay, 4th April.
I'm sorry. Deeply obliged.
78.
This is my application.
So I'm sorry, interim order to continue.
Interim order to continue.
Sorry.
Mr.
may it please
Majumdar
your
is
lordship.
appearing in this matter. Mr. Majumdar is appearing in this matter. I filed his appearance memo on behalf of the petitioners.
All right. May it please your lordship, that the impugned order is not only in violation of the principles of natural justice, but also suffers from jurisdictional error. What has happened in this matter, well, a show cause notice, if your lordship kindly allows me to file a short list of dates.
No, but is this an appealable order, sir?
Well, appealable order, but in excess of jurisdiction. Clearly, well, kindly bear with me for 2 minutes, your lordship. On 26th of February 2010, show cause notice is issued regarding availment of SENVAT credit, wrongful availment of SENVAT credit on common inputs for dutiable goods and exempted goods. On 8th May 2010, the lordship can amended so. Kindly take the list of dates for months.
Yes, yes.
Commissioner issued a show cause notice on 26 February 2010. But the show cause notice did not disclose that it was a precautionary show cause notice in view of the audit objection raised by the Office of AG Orissa, and the department registered its demand against such objection. On 8/5/2010, Rule 6 of the SENVAT credit rules was amended by Section 73 of the Finance Act 2010. On 29 July 2010, that is after the issuance of show cause notice, the jurisdictional central excise officer informed the petitioner about the amendment made to Rule 6 and gave the petitioner an opportunity to avail the benefit of amended Rule 6, which covered the period in question. On 2nd November 2010, the petitioner requested the commissioner to drop the proceedings and that it had reversed the SENVAT credit and paid interest. On 12/10/2012, the petitioner submitted further reply to SCN and reiterated his stand. Then, my lord, on 8/1, my lord, the proceedings were revived, retrieved from the call book sometime in the later part of 2017. My lord, we submitted our written notes. My lord, we were not informed that the matter was sent to call book. It is only at the stage of when the order in original was passed, it appears from the order in original that the matter was sent to call book. The department registered its objection, and the objection was accepted by the Office of Controller and Auditor General Orissa Office, AG Orissa. And after this retrieval, the proceedings were continued, and, my lord, then the order in original was passed. First, it is in violation of principles of natural justice because at the stage of show cause notice, we were not informed that it was a precautionary show cause notice as indicated in para 4.6 of the order in original. But the lordship will kindly take the order in original for once. Kindly take, my lord, para page 51.
Department.
Earlier occasion I am appearing now. Mr. Satpathy will appear in this case. That time I appear as a capacity of senior standing also. Now I can't appear, so Mr. Satpathy will take part. What I remember that it is appealable, and but they are not impugning the same ground we were taken before the appeal authority.
Correct. My lord, it is a question of error in jurisdiction. The audit objection was raised during the relevant financial year. At that stage, my lord, there was no occasion to make an application or make payment or reverse the SENVAT credit. After the show cause notice, my lord, the credit was reversed. Pursuant to, my lord, a communication made by the jurisdictional central excise officer. Once that communication is made, my lord, I put the question to myself with all humility. Would the show cause notice stand? Because I made the payment subsequent to the issuance of show cause notice. And my lord, when the audit objection was raised, my lord, this was not the jurisdictional fact. But the jurisdictional fact which was existing at the time of the audit objection was no longer existing on and from 2nd November 2012, say 2010. It could not have existed. So first is the lack of jurisdictional fact. Second, retrieval. Kindly take the issue. The period is 2005-6 to 2007-8. My lord, I made payment of, say, reverse the SENVAT credit in 2010. I paid interest as per Rule 6. Malad, in the order in original, the adjudicating authority examines as to how I have not complied with the requirements of Rule 6 as amended by Section 73 of 2010, as amended by Section 73 of 2010, Act 2010. But that was not the subject matter of show cause. They could have dropped these proceedings and initiated a fresh show cause notice. They didn't do so. They sent the matter to the call book and it was retrieved later on in 2017. It's a clear case of excess of jurisdiction.
Which can also be urged in the appeal.
Malad, kindly bear with me, Malad. This is a case, your lordship will kindly take.
We have been very patient with you.
Yes, Malad.
Every time I ask you a question, you suddenly say, bear with me. I don't mind.
Malad,
you can carry on. No problem. Malad, if I should not ask a question, I will not ask.
No, Malad. Only one way, if it doesn't appeal to your lordship, certainly, Malad. But one page in original for once.
All right.
Just one. Kindly take paragraph 1.3.
Yes.
Malad, this is for the first time we were informed, page 43.
Yes.
The allegation made in the aforementioned SCN. Malads have got that?
Yes, yes.
Were based on the observation made by the AG of Orissa.
Right.
Then, my lord, kindly take paragraph 4.6.
Yes.
At page 51.
Yes.
As has already been discussed, the subject SCN is the outcome of audit objection of AG Orissa raised in para 5 of so and so. Even though the audit objection was well contested by the revenue, the instant SCN was issued as a precautionary measure as per board circular dated so and so. The show cause notice were not adjudicated and instead it was transferred to the call book. Subsequently, the IR was converted into DAP and audit para number so and so. Finally, the contention of the department has been accepted and communicated by the letter of Commissioner PSC Vide, letter dated so and so. The letter on board Vide circular dated 8/4/2016 issued detailed guidelines about adjudication of show cause notices issued on the basis of SERA CRA objection. At para 6 of this circular, the board has clarified that the show cause notices relating to audit objections figuring in the list should not be adjudicated and further action should be taken in consultation with the Commissioner PSC. Rest of the objections stand finally vetted by CAG's audit and no further comment, which meant that the reply of the department had been accepted by CAG's audit. So, my lord, the audit objection was contested by the department and the department rebuttal was accepted by the CAG office. And at the stage when the audit objection was raised, there was this fact of this amendment to Rule 6 was not there. I made a payment subsequent to the issuance of show cause notice, and that has been adjudicated in this order in origin.
All right.
So, the adjudicating authority has traveled beyond the scope of the show cause notice, and your lordship will find from the show cause notice, which is at page 75.
Yes.
There is no reference to the fact that the show cause notice has been issued on the basis of audit objection.
All right.
And the copy of the audit objection or the rebuttal was not provided to me.
All right. You see, the challenge in the present petition is to both the show cause notice dated 26th February 2010, issued by the Commissioner, Central Excise, as well as to the adjudication order dated 27th April 2018, confirming the demand raised in the SCN paragraph. While issuing notice in the present petition on on 3rd April 2019, this court directed that no coercive action would be taken pursuant to the order dated 27th April 2018. On 23rd October 2019, it was clarified that the order impugned, if implemented, shall be subject to the result of the writ petition. Paragraph. Again, on 20th November 2019. The earlier interim order of 3rd April 2019 was continued, and that has not been varied since. Paragraph. This court has heard the submissions of Mr. Abritosh Majumdar, learned counsel appearing for the petitioner. Stop. The main grounds on which the impugned adjudication order has been challenged is that the commissioner travelled beyond the scope of the original SCN as reflected in the impugned order. Full stop. It is submitted that the impugned order was based on certain audit objections which did not form the subject matter of the original SCN. Full stop. Further, it is submitted that by virtue of the amendment to Rule 6 of the Senvat Credit Rules 2004, by this Section 73 of the Finance Act 2010, the jurisdictional fact regarding wrongful availment of credit by the petitioner no longer survived, since it had by then reversed the credit and paid the interest amount. Paragraph. Admittedly, the adjudication order is an appealable one. Full stop. All the grounds urged by learned counsel of the petitioner before this court and as pleaded in the petition can well be urged in the appeal to be filed against the impugned order. Full stop. Consequently, while not being inclined to interfere with the impugned order, the court permits the petitioner to file an appeal thereagainst as provided in the statute in question in accordance with law. Full stop. If such appeal is filed not later than February 2023.
Well, we will file it within 4 weeks. We'll do so.
All right.
We'll do so.
9th January 2023, accompanied by an application for condonation of delay, explaining the delay on account of the pendants of the petition. It will be considered in accordance with law by the appellate authority. By the tribunal.
By the tribunal.
By the tribunal. Full stop. Till such time, the tribunal passes an order on the application for interim relief. The interim order passed with this court on 3rd April 2019 will continue.
My lord, only one submission. My lord, if we make an application, we prefer appeal within 4 weeks. But would it be your lordship's pleasure to direct the tribunal to dispose of the appeal within 6 months or something like that?
Yeah, it will be open to the petitioner to request the tribunal for expeditious disposal. All right.
Your lordship say that revenue has filed the counter appeal in this case.
That's all. It's all part of the record. All right.
That's a formality. Grateful.
79.
May I please, your lordship?
My lord, in this case, I am appearing today on behalf of my lord, OP number 5, my lord. 2 weeks time may be granted for filing written reply, my lord.
Well, here the fact is that the opposite panel 5 passed the attachment order, bank account attachment order under section 79, one of the GST and CGST Act, which section 20 of the IGST Act. Such order of attachment is passed when the appeal is pending, my lord. Appeal order is pending, my lord, by violating section 107 of the OGST Act, my lord.
You have to file the replies, sir.
Well, I have deposited 10% of the demanded amount and I have filed the appeal. Appeal is admitted, hearing is going in. Finally, a hearing has been completed. No final order has been passed. In the time, when opposite panel 4 is a party to the dispute, well, he has filed passed that annexure 1 attachment order. I am facing a lot of difficulties.
What is the difficulty? Tell us, sir.
I am not operating in my bank, my lord.
How much is the amount in your bank? What is the balance in your bank?
Balance is, my lord, in this case, my balance is 0, my lord. It is a saving bank account.
That's why I was asking him. When I ask him a question, you are able to answer. That's very good. It's a good system. But I'm asking him the question.
The balance I have to take the instruction, my lord.
So whenever you take that, sir, we'll consider it at that stage.
Well, only
the
that
counsel appearing for opposite party number 5 has entered appearance and seeks and is granted 4 weeks time to file a reply. The other opposite parties will also file the replies at the same time. Rejoinder be filed before the next date. List on.
Yeah.
25th January. 25th January.
At number 80, no instruction.
Dismissed. No instructions dismissed. Right.
81.
The petitioner.
There
was a misunderstanding.
I see.
The inflow of high voltage, in fact, the entire locality people are affected.
Okay.
Computers are damaged. And
there is spike. Sudden spike.
Yes. Part of my chamber, the cabin where I used to sit, burnt.
Oh, my goodness.
Luckily, we are not there. We are
I know.
Yes, ma'am. God saved my files and books. They are all saved.
All right.
But here is a OS shop licensee.
Yes.
He was directed to close the shop on account of a mistaken fact that the shop is running over a DT's land. In fact, thereafter, when we filed the case, they conducted inquiry. Page 3 of their counter, they have admitted that the property is a private property and they have restored my shop. If your lordship sees flag B, after the interim order was passed, they restored my license. Page 9,
yes.
Taking help of the interim order passed by this honorable court.
Right.
Now that they have admitted that it's over a private property, page 3, middle paragraph, the inquiry may be permitted to place it.
Yes.
Counter affidavit by the state.
Yes.
The inquiry report of Tahsildar Kodala by Deputy Superintendent of Excise Ganjam reveals that present Kodala OS shop is running over plot number 5288, khata number 1520 so-and-so of Mauja Kodala, which stands recorded in favor of Patnaik so-and-so. Detailed inquiry report by letter number so-and-so dated 12/8/2016 is enclosed during the annexure CY1 for kind perusal of the court. And if a lordship sees the interim order dated 2nd of November 2016, that will in fact end the problem, except of course the demand during closure period. Lord, kindly see order number 3. It is brought to our notice that based on a complaint lodged against operation of the petitioner's OSAP, inquiry was conducted by RI so-and-so Tahsildar Kodala Ganjam, the Deputy Superintendent of Excise Chhatrapur Ganjam, as well as the Collector Ganjam, and views of all the authorities were intimated by the Collector Ganjam to Additional Secretary to Government Excise Department Odisha, Bhubaneswar under letter number 1817 of August 2016, the relevant portion of which is quoted hereunder. Besides, khata number 833 is recorded in the name of Sri Barala Balukeshwar Swami, whereas plot number 5092 is not recorded in khata number 833. Moreover, the present OS shop Kodala functioning over plot number 5288 under khata number 1520 by 475 in Moja Kodala is also not coming under khata number 833. The report of Tahsildar Kodala and Deputy Superintendent Excise Ganjam along with the trace map of RI Kodala is enclosed here for your kind perusal. It is indeed surprising to note that under 7/10/2016, the Government of Odisha in Excise Department, with reference to the very self-same letter of the Collector Ganjam, has directed closure of the shop. It clearly perhaps indicates non-application of mind to the communication of all the authorities who have inspected and submitted factual report to the state. Accordingly, interim measure, it is Director of Operations so-and-so shall remain abeyance. The order by which they closed my shop. In fact, this honorable court at the interim stage has taken note of these developments, and in the counter, coupled with the fact available in the counter to my closure to the cause of action to the closure, my lord, your lordship can pass an order referring to the interim order to be made final, because they have made my shop operational subject to order passed by your lordship. If your lordship sees my flag B, page 9.
All right. So now the shop is operational, we can close.
Shop is in operation. That is it. But what my learned friend is saying, that due to that particular reason that the land is not recorded in it, that is not the only reason. The next para is para 6. That after careful consideration of the report of the Collector Ganjam, the government has passed order for closure of the Kodala mine shop on the grounds of local objection and exhibits.
But now you yourself have revived it.
And that is due to the court's order. We have allowed him to operate.
That's okay. You see, on 2nd November 2016, while directing notice to issue the present petition, the following order was passed by this court in Miss Case number 17416 of 2016. Paragraph. Just that whole order you quote. In the counter affidavit filed by the opposite parties, the above fact is confirmed. Stop. However, the closure of the shop was still justified on the grounds of local objection. Stop. Paragraph. Nevertheless, it so happens, it transpires that during the pendency of the present petition, the collector, by an order dated 30th November 2016, allowed the opening of the shop on 2nd December 2016. Right. So the shop has been operational since then. Paragraph. In view of the above development, the original order passed by the Excise Department on 7th October 2016 is no longer legally sustainable and is hereby set aside. Paragraph. As regards the
demand during closure period.
Yeah, demand during the closure period, the petitioner
to approach the
excise commissioner with an appropriate application.
For exemption.
Yeah, for exemption, which will be considered in accordance with law. An appropriate order passed within 4 weeks of the making of such representation. Which should be made not later than 4 weeks from today. Paragraph. The writ petition is disposed of in the above act.
The interim order dated 30th of March 2017.
Yeah, the interim order is made absolute and then the petition is disposed of.
And the demand was stayed by this Honorable Court on March 2017.
So far as demand is concerned, your Lordship has passed observations.
That demand is kept in abeyance by this Honorable Court by another order.
That will remain kept in abeyance till the Excise Commissioner.
Right, that's what I'm saying.
Okay. Till such time the Excise Commissioner decides on the above application of the petitioner. The demand which was stayed by this court by the order dated
30th of March 2017.
30th March 2017 will continue to remain in abeyance.
Right.
Right.
Correct.
82. Demand of central excise duty on royalty by MCL. You passed the similar order. Covered by your Lordship's order.
All right. All right, same order.
Obliged.
83.
This is perhaps infructuous.
No. Lord, it's a question of interchangeability for the year 2016-17, interchangeable MGQ. Lord, after we raise a grievance before this Honorable Court, pursuant to the orders passed, government has taken a policy decision allowing interchangeability throughout the year. The issue was they allowed interchangeability for part of the year, rest part the government did not allow. Now that government has taken a stand, passed an order that interchangeability throughout the year is allowed. So taking that into consideration, this may be disposed of because that
okay.
will
So rather submits that in view of the subsequent policy change in the government allowing interchangeability throughout the year.
Yes.
The petition is not pressed and it is disposed of as such.
But throughout the year, for the year, through the year 16-17, kindly specify that. 2016-17. I'm sorry.
Or 2016-17.
Yes, let that not be confused.
All right.
So many cases, so he is confused. So many files.
All right.
84 not same.
84.
Interchangeability, that's 84 same. Same order.
Same order in this.
No, it is a demand notice.
Demand has been raised part of that. It is if it is entire year, then there will be no demand.
All right.
Lordship says if interchangeability entire year will be allowed, there will be no demand.
Then what is the effect of the demand notice? That has to be observed by the Honorable Court.
You decide. Interchangeability you have given.
Then so far as the demand notice is concerned, the commissioner will take a call. You approach this.
All right.
Because that is more, the impugned is demand
notice. You say counsel of the petitioner points out that for 2016-17, the government has subsequently made a policy change permitting interchangeability throughout the year.
Under Annexure 2.
paragraph. In that
given,
the
I've given.
matter, the demand notice dated 7 March 2018 will have to be re-examined by the commissioner in light of the above policy change.
Yes.
And the petitioner will file an appeal against that or representation, whatever your lordship will.
I'll file representation.
The
Yes.
petitioner's representation to the commissioner will be decided within 4 weeks of it being filed. Provided it is filed within 2 weeks from today.
But interim order to continue because interim order is
Till
there.
such time the excise commissioner decides the said application. The interim order passed by this court
29/3/2018.
on 29th
3/2018.
Yeah, March 2018, staying the demand will continue. All right.
Obliged.
85. No instruction, your lordship.
Counsel, the petitioner states there is no instruction. Dismissed as such. All right.
86.
86. My lord, we are for the villages petitioners we are. And we are objecting on opening of IMFL offshop in that Langaleshwar village, Gram Panchayat, under Nagardia Patna Moja. But that objection was not considered by the appropriate authority. That's why we may pray before Lordship for fresh representation and for that.
No, but where's the question of again representation here?
How many representations?
Yeah.
He has filed several petitions. My lord's lady.
See, there was a public objection on 5th November.
He has never responded.
Public objection notice on 5th November.
Yes, ma'am.
This particular shop is locked in litigation for last so many years.
Villagers of that village are objecting because.
Now, one by one, if you will come, then the department will deal with all these things.
Actually, they want to shift that place to another place that is called.
My lord, there is a procedure of shifting.
See, para 9 of the counter affidavit, in response to the public notice, no objection has been received within the stipulated time period.
And apart from that, your lordship will see, so far as shifting is concerned, it is a part of the policy. If somebody is aggrieved and being an aggrieved person, he can challenge shifting order not by filing this PIL.
Then your Sarpanch says she has no objection for opening of the Langleshwar IMFL off shop.
Yes.
At Patharkota, Moza.
No, my lord, Sarpanch also agreed with the villagers of that village because at shifting of that IMFL off shop, my lord, have a glance at number 8, in page 3.
See, there's only one approved Moza, which is Nagardiha Patna.
Nagardiha Patna.
So how can you shift it to that Patharkota then?
If your lordship will see page 16, the order of the excise commissioner that is annexed to the counter affidavit, it is everything has been dealt with, all that is annexure 1, page 13. Page 13, annexure D/5. The order of the excise commissioner. And this Jogi Boidyo was the appellant before the commissioner. If at all he is aggrieved, he has to file, or anybody is aggrieved, they have to file the revision before this the government against this commissioner's order. And everything has been dealt with. So no further litigation should be encouraged because the commissioner has already decided the dispute.
The present petition seeks a direction to the excise authorities to allow the off shop of opposite party number 6 to be shifted from the present site at Nagardiha Patna to Patharkot Moza site under the Langleshwar Gram Panchayat area, (GP) area. Paragraph. The background facts are that on 5th November 2021, a public objection notice was issued in respect of opening of the IMFL off shop for the district of Ganjam for 2022-23, including the Langleshwar IMFL off shop. at the approved Mauza, that is Nagardiha Patna. Stop. An objection was received on 22/11/2021. Sorry, an objection petition dated 19/11/2021 was received which was inquired into by the Inspector of Excise, Chhatarpur Sadar. Full stop. It appeared that the villages of Pendrupalli under the Langleshwar GP had submitted a petition that the licensee should be allowed to operate, allowed to shift to the Patharkot Mauza. Full stop. The stand of the excise authorities is that the approved Mauza is Nagardiha Patna, and therefore the shop cannot be shifted to the Patharkot Mauza, which is not approved for that purpose. Full stop. The matter was examined by the Collector and District Magistrate Ganjam, and the Excise Commissioner has also dismissed the appeals filed by certain other villages in this regard. Full stop. Paragraph. With the matters having already been inquired into at all levels, and it being found not feasible to direct shifting of the off-shop to a non-approved site at Patharkot Mauza, the court rejects the prayer made in the present writ petition. The writ petition is accordingly dismissed.
Pardon, Your Lordship. Just I am the conducting counsel in this matter. I just want to appraise two facts, Your Lordship. What has happened in 2021? The current licensee, he opened the shop in the Nagardiha Patna Mauza, which is the proposed site. The villagers objected, and on the objection, it was shifted to Patharkot Mauza way back in 2021. He operated in 2021 for some days. Again, the authorities told that it was not the proposed side and asked the licensee to transfer back to the Nagardiha Patna, which the villagers objected. And after that objection in 2022-23, again a fresh public objection was called for. The last date was 21 November, Your Lordship. I had posted that objection. The villagers posted the objection on 19th, but it was received on 22. The last date was 21th, Your Lordship. So what has happened? They haven't considered our objection, which we have filed our objection earlier in 2021 also. So now what has happened? Both, I agree to that. There's the state exchequer and the licensor, both are the sufferers, because it is the revenue loss that the state is also burdening with. My only humble submission will be that Patharkot is an unobjectional site that the villagers have put before the authorities, that the Collector Ganjam, that Patharkot Mauza is the unobjectional site, which may be considered, Your Lordship. That is my only humble submission.
But it's not an approved site, so we can't compel them to
the authorities may kindly consider that, because there is a strong public objection in the approved site, Your Lordship.
No, that's all right. Yes.
87.
My lord, in this case, the Honorable Court has directed to reconsider the proposal, and we have reconsidered it. Collector has given a favorable recommendation.
All right.
And the matter is now pending before government. I pray 10 days time, we will pass
So
it.
let the matter be kept pending, my lord. That is-
Yes, it pending. 10 days after 10 days.
As a request of Mr. Monty, learned AG, list on
17th.
Okay, 17th December. So 19th December, sir. Late.
Obliged.
Late 19th. Right. We'll continue after lunch.
My lord, 1 minute if your lordship.
No, no, tell it.
In that personal appearance matter, what has happened? Only 1 minute I will submit, then I will. That is regarding organization of blocks.
Correct.
That is totally under the control of Panchayat Raj department.
Right.
It is not the revenue department who is doing all these things. And deliberately or not deliberately, the petitioner has not implemented the Panchayat Raj department. Panchayat Raj department is reorganizing the blocks of panchayats, everything. Your lordship may kindly imagine. This is a reorganization of panchayat. So Panchayat Raj department is supposed to file the affidavit responding the allegations of the petitioner, not the revenue. I have discussed with the revenue secretary now, and he has said so that it is not under our domain. I respect your
So I
lordship.
will change that to Panchayat Raj.
My lord, one thing I can, because Panchayat Raj department is not a party. So I pray that let it be called after. I will inform the learned counsel who was appearing for the petitioner at 2 p.m. After the Strera case, it may be taken up. Whatever your lordship will think proper, your lordship will pass order. Only 1 minute, your lordship will hear me. I will ensure the presence of the petitioner's advocate at that particular time, and whatever the learned advocate general will also come at that time. And your lordship.
All right.
Oh.
Act doesn't fall into the category where restriction has been imposed by the said public notice. The project which has received completion certificate under Section 20 of the ODI Act and has been granted occupancy certificate in such form under Section 20A of the ODI Act by Development Authority, authorizing occupation of the building.
I think
then
the
project. No, that is not the affidavit which you have served upon me.
No.
Filed on 3rd December, I think.
No, that is not the affidavit. I'm giving you an affidavit.
They have served upon
who
me.
has served on you?
That is bears the original signature of the IGR.
We will give you a certificate.
My lord, may I see this affidavit then?
This is not that affidavit.
No, this is what has been served upon me.
3rd December.
I don't think.
December, you see.
My lord, may kindly see this is what they have served upon me. I don't know which.
No, that is the wrong affidavit, Lord.
I don't know how they can now change their stance, my
that
lord.
is your problem. That is your problem.
My lord, it bears the original signature of the IGR and the ASC. I don't know now why they are blaming me. They have served this upon me.
You get a
Para 4 of this affidavit.
Anyway, my lord, that affidavit is not the affidavit, the one which has been filed before your lordship. That is the affidavit.
Treated as I don't know.
What they have served upon me, I am only arguing that
Change this. I think you should serve the right affidavit.
No, no, right after I already saw.
No, this bears the original service now. I don't know what
I will serve it.
say.
I will serve it now.
No, what they are trying to say, I don't
Yes.
understand.
My lord, let me tell you, Lordship, what is his application?
My lord, here they have then completely changed their stand, my lord.
Yes, yes, I have. I have settled that affidavit. You can't have a problem with that. Huh?
My lord, they are intimidating me, not allowing me.
No, no one is intimidating you. My lord, would his lordship look at his application? Kindly see that.
My lord, what I may pray, let me start. I'll not take more than 5 to 7 minutes.
All right.
I'll not take.
Let's read this para 4 anyway on this affidavit.
Of this affidavit. Exactly, your lord. It is clarified that the word completed in the public notice issued by the answering deponent dated refers to the project which has received completion certificate as defined under section 2Q of the RERA Act before 1/5/2017, the date of implementation of the Act.
In such form and such terms and conditions.
In such form and condition as may be prescribed by the competent authority. Now, the completion certificate has to be issued by the competent authority. The problem lies there. Who is the competent authority? Now, I would like just your lordship to take to the RERA Act, your lordship.
RERA Act.
My lord, sorry. My lord, section 2Q.
Hmm.
2Q speaks about the definition of a completion certificate.
Right.
I'll read it. Means the completion certificate or such other certificate by whatever name called, my lord. This is important. Or such other certificate by whatever name called, issued by the competent authority, certifying that the real estate project has been developed according to the sanctioned plan, layout plan, and specifications as approved by the competent authority under the local laws. So it has to be issued by the competent authority and it has to be as per the sanctioned plan approved by the competent authority. Now, my lord, just above that 2P, it says definition of competent authority. It means the local authority or any authority created or established under any law for the time being in force by the appropriate government. There are two tests: which exercises authority over the land under its jurisdiction and has powers to give permission for development for
One
such.
thing is clear. Once they set completion certificate in 2Q says it will be issued by the competent authority.
Now, who is the competent authority? There the dispute lies. Because
local authority or any authority created or established
under any law for the time being enforced by the appropriate government.
Correct.
Then there are two tests: which exercises authority over the land under its jurisdiction and has powers to give permission.
It has to be some governmental authority.
Exactly, my lord. Now, what they are trying to say.
Now, no question of any more trying to say, which is why we called for this affidavit.
Yes.
Nobody can say anything contrary to this now.
That is what they are saying, that an architect is the competent authority.
No. See, this affidavit does not say architect is the competent authority. Yes. If in a particular case they treat the architect as a competent authority, that will be questioned.
That, my lord.
More than this, see, this is only clarifying a legal position.
Exactly.
Individual cases, whether the completion certificate satisfies the description of 2Q, will be examined on a case-by-case basis.
Yes,
we can't have we can't think more than because if the authority,
indeed, your lordship,
has issued this clarification, that's the end of the matter.
Yes, but he stops at that. My problem is that he stops at that.
He should not say anything more, if you ask me, because he has said 2Q.
2Q only.
2Q read with 2P makes it clear who the competent authority can be,
yes,
and who will issue the completion certificate.
I only want that clarification that competent.
No, he has already issued this clarification saying completed means completion certificate having been issued in accordance with 2Q.
2Q, and it has to be issued by the competent authority.
Yes. That's what 2Q says. Why add anything more? 2Q. Because 2Q says issued by the competent authority.
But that is not happening in the state of Odisha.
That we don't know. If it doesn't happen in individual cases, that will be questioned.
Yes, that's correct. But because your lordship's order is trying to be circumvented.
No, there will always be people who want to circumvent something or the other.
Exactly.
But there's a limit to what a court can do beyond clarifying the correct legal position.
The legal position.
Individual cases, it will get tested.
In my affidavit, I have also indicated that where this problem has happened, actually. My lord, they have held the architect to be a competent authority, and accordingly, the projects have been removed from the purview of the
affidavit of yours?
My lord, 2/12/2022. Your lordship may see page 15. And the RERA issued a clarification that occupancy certificate will be held when a project is complete. But contrary to that, now the architect is being held to be a competent
So in
authority.
those cases, you will permit affidavits to be filed on the basis of the clarification issued now by the IGR.
That the architect,
Those are pending cases in that this affidavit can be relied on.
architect should not be the competent. Otherwise,
So once this affidavit has been given by the IGR himself, clarifying what he meant by completed, that will now hold the field.
Because the earlier affidavit which they served upon me, that was
No. This is the affidavit. This is the affidavit that's come on record.
May I make a couple of submissions? My lord, may I make a couple of submissions? Your lordships are aware of the RERA Act. There's a transition provision on that act. Now, what happens to the buildings which have been completed prior? And what happens to the buildings which have completed after? The Act itself says, my lord, that ongoing projects will be covered under the Act. The whole exercise is to get back to a point of time for buildings which were completed prior to the RERA Act having come in force. Now, my lord, there is a direct judgment of the Supreme Court on this. And if your lordship don't mind minutes,
but
if your lordship not going into it, I'll leave it at that.
No, because nobody has raised the issue right now. The only doubt was because the IGR, I think what the IGR did was invite more trouble for himself.
Yes.
By using a vague word called completed, which is not. See, which is why we say authorities have to be very conscious because they're putting out something in the public domain.
Yes.
They're purportedly clarifying issues.
Correct.
But they're adding to confusion by using terms which are not used in the Act.
Your lordship is right. My lord, let me tell you, lordship, what is the genesis of the whole thing? Why it happened? My lord, I undertook before your lordships that till an act is framed and an association in terms of the act has been made, there will be no registration. There will be no registration. We are very clear about it. The state is very clear about it. But what happened was that there were certain buildings which had completed much before RERA came. For instance, 5 years, 10 years, 15 years, 20 years. And when they came for a resale, there was an injunction there also. So, my lord, therefore the question is...
That is not because of the court's order. It's something...
Not because of the court order. No.
In fact, I wondered when this was said last time.
My lord.
Why would something not get registered for 5 years? Because the Act has been in force since January 2017?
Yes. I'm grateful. I'm grateful.
That raises more questions than it answers.
Correct.
So something not getting registered for 5 years, and if you say, what you say is right for 10 years.
No, not registered. No, that's not registration. I think I have not been able to. I have not been able to make my point clear. But for example, I have purchased an apartment 10 years back, and today I want to sell that apartment. What was told is that you can't even do that.
No, who was told?
My lord, your lordship understands who has told this. Somebody obviously this side, not that side. Somebody obviously this side.
There is no
this litigation that is more than that meets the eye.
That's correct. So we cannot resolve problems that
I've gone into this in such great detail.
Correct.
And I see all kinds of messages in public media now that High Court has injuncted this, that, all kinds of things.
So many, my lord, you must in fact
to cut it short, my lords. For example, he has filed another affidavit saying that some building did not have a fire certificate. And therefore, it could not have been granted a completion certificate. I called the officers. I said, how can you grant somebody a completion certificate without a fire? He said, sir, fire certificate is given by the designated person who is empaneled, seeing that the building is as per the building plan. Now, completion certificate. Occupancy certificate, when they will go, they will give all the other necessary agency certificates. So these are the confusions that are being created. That's all I wanted to say.
May I add a few points? Your Lordship may kindly edit petition if your Lordship is holding the first one. 18799, this Bimalendu Pradhan.
Yes.
In which your Lordship may kindly turn to paragraph 4.33 of the writ petition. Not only 1-2 submissions I will advance with reference to, of course, REACT. Para 4.33.
Yes.
That the first writ petition. Milord, may I read with your Lordship's kind permission?
Yes, yes.
That the petitioner has booked and purchased a flat at the real estate project constructed by Messrs. Bipul Limited, Bhubaneswar by paying a consideration amount of such and such amount. Now, due to non-formation of association of allottees, the petitioner fears that the maintenance of common facilities, etc., Milord. Lord, may I read the full paragraph?
No problem,
The petitioner, yes, may I read, Milord? The petitioner had filed CC number 55 of 2008 before the opposite party number 4, Lord Rera, against the builder, wherein by order dated 12/6/2018, which is appealable, the opposite party number 4 had directed the builder to form an association of allottees within 2 months and hand over the common areas of the project to the association of allottees. However, till date, the said order could not be complied, as because there is no provision in the state of Orissa for formation of an association of allottees. Lord, one submission. Lord, this has been given the trappings of a public interest litigation. Lord, I'm sorry to make this submission, but the private, especially, he is an allottee. He intends to, Lord, that is fine. We are also with his stand. I do fully support and endorse. Lord, I am for the Promoters Association of the state. As if, Lord, a picture is being given that as if all the promoters of the state have some ill intention and non-formation of association is the consequence. Lord, may I take your Lordship to section 11 and 17 for a time, for a moment? Your Lordship may kindly have a glance at section 11. Thereafter, Milord, I may refer to his prayer in the writ petition. I reserve it for the time being. Your Lordship may kindly come to section 11. Milord, the whole chapter 3 that deals with the functions and duties of promoter. Milord, the functions the promoter shall, upon receiving his login ID and password under clause A of subsection 1 or subsection 2 of section 5, as the case may be, create his web page on the website of the authority and enter all details of the proposed project as provided under subsection 2 of section 4 in all the fields as provided for public viewing, including details of the registration, etc. We are not concerned. We are concerned with subsection 4, Milord.
Yeah, 4A.
Your Lordship may, yes.
4A.
4A. The promoter shall, look, your Lordship may kindly look at the language. Be responsible for all obligations, which is a compulsory function. Milord, be. It starts with the opening word, shall be responsible. Lordship kindly mark the language of the legislature. Milord, C also.
E. Now
be responsible. Milord, we are concerned with E. I am grateful.
Yeah, enable.
The enable.
Right.
Milord, why this particular word enable instead of be responsible has been used? Maybe your Lordship has to, Milord, maybe required to interpret this.
Right.
Milord, your Lordship, these may be the legislature foresee.
Yes.
Maybe there may be an eventuality where this association may not be formed by the promoter at all. But that is the larger issue. Because I think this point Milord, I am grateful to your Lordship that nowadays this digital live streaming telecast of your Lordship, I would listen to all the proceedings, previous proceedings.
The proviso is important.
Yes, no, that is very important. I am reading the whole. Provided that in the absence of local lodge, the association of allottees by whatever name called shall be formed within a period of so and so. Your Lordship may kindly now turn to section 70. That is very important.
No, but this is...
No, your Lordship, it is to be read with 17. That is what I am taking your Lordship to 17. This is reference to 17. That is what their prayer is also in the writ petition. Milord Lordship may kindly turn to 17, transfer of title. Milord, why this question is the crux. The promoter shall execute a registered conveyance deed in favor of the allotee along with the undivided proportionate title in the common areas to the association of allottees or the competent authority. Milord, I think my learned friend is stopping here. Or the competent authority. Milord, why this expression has been used may be forcing an eventuality or a situation where the promoter, Milord, doesn't, Milord, for some reason fails to form an association, because your Lordship knows that trade, Milord, essentially inherits from Article 19(1)(c), and that freedom has been given to a group of people, or Milord, the number, whatever may be, as per the, Milord, your Lordship may kindly come to this, sorry. Where is that? Association or cooperative? Where is it? No, Milord, your Lordship, no, society association. 11(4)(e). Yes. Yes, Milord, 4(e), your Lordship may kindly read this. Enable, I didn't read the whole, I'm sorry, Milord. Enable the formation of an association. Milord, this E again I am taking, your Lordship. Formation of an association or society or a cooperative society, as the case may be, of the allottees or a federation of the same under the laws applicable. Let us first stop here, unless, because the proviso will go. There are no doubt the Societies Registration Act is applicable to the state of Orissa. Number one. Number two, Milord, there is a Odisha Cooperative Societies Act, Milord, which also provides for the formation of the association or the cooperative bodies. Milord, third is a society, Milord, which is not otherwise conflicting with this. That is a freedom or a choice left to the allottees to form any kind of association falling under this E. Milord, of their choice, the promoter can, Milord, on his own promote a cooperative society and ask the allottees to become members of it. That is why, Milord, no, Milord, this is my, why I am, Milord, arguing this particular aspect. Milord, no doubt, the Association Registration, Societies Registration Act 1860 is applicable to the state of Orissa. Milord, on the last occasion, the RERA authorities came forward with a model bylaw in exercise of power under Section 37 of the RERA Act, Milord, for the, which protects the interest of both the promoters and the allottees. So therefore, Milord, for the infrastructure development of the state, which is the basic object of the RERA has been vested with enormous powers, including the power to issue directions. They come forward with a set of memorandum of bylaws, etc., which has been vetted by the IGR, Milord, that is in conformity with Section 20, read with Section 1A as per the Odisha Amendment. Your Lordship may kindly have a glance at Section 1A of the Societies Registration Act. 1A. Milord, one moment. Your Lordship may kindly, it's a very serious matter, because registration, it is against the interest of the allottees. Thousands of allottees, Milord, are moving here and there because they can transfer their property, as the learned Advocate General argued. Somebody is seeking an education loan for the daughter or son, he is not able to create a mortgage in favor of the bank. Somebody is, Milord, wants to spend money for the health, medical treatment of the old parents, he is not able to sell the land. Milord, your Lordship may kindly turn to 1A.
Mr. Acharya.
Yes. No, 1A, I'm just fine, I'm submitting this, Milord.
No, can apply for permission to speak?
Madam, sir.
Thank you for your permission.
Sir, Milord, no, I am not.
No, please. We are here not concerned with inability of people to sell their land.
That's correct.
Let's be very clear what this petition is about.
That's correct.
This court has never issued any injunction about somebody selling land.
No, unless it is registered, Milord, it can be sold.
So let's not pitch this saying there are people waiting to marry off their daughters, they're not able to sell their land. This case is not about that at all. I want to make this absolutely clear. I don't want people to get the impression that the court has somehow stopped all transfers all over. So
that is what
the court has done. None of that sort. The court's orders have to be read carefully to see what the court has done.
That's correct, Milord. You will also clarify.
If people misunderstand and misinterpret, Mr. Acharya, if people misunderstand and misinterpret the court's orders, the court cannot be held responsible.
Your Lordship is absolutely.
So we leave it at that, because if you have an apprehension that somebody from the side of the state has misinterpreted the orders of the court, it's for you to
that's
convince them that this is the wrong understanding of the orders of the court.
Your Lordship may kindly clarify that, because the impression.
In fact, this is all your own. That's what the Advocate General was very candid, saying the mistake was perhaps on their side in misunderstanding the orders of the court.
That is correct. My Lord, 1A. Your Lordship.
I don't want anyone to carry this impression.
No, that's correct. I'm grateful, my Lord, for making this clarification.
We are only concerned, and Mr. Acharya, let me make this very clear.
Yes.
There were definitely, and from what you're reading now, it appears that there are more ambiguities than we noticed earlier.
That's correct.
So if there are so many ambiguities, those have to be clarified.
That's correct.
Otherwise, the very people for whom you are standing up, they will be in deep trouble.
No, that is what
I keep telling all of them on your side, because you're all very emotional and passionate. Understandably.
No, that's correct.
Because you are good advocates, you have to argue the case of your clients.
That's correct.
But you must also understand that you must argue something that actually ultimately helps them.
That is the argument. I'm concerned about that.
Confusion when it comes to your own client, whether he is a promoter, whether he is a builder, whether he is an apartment buyer. If it adds to their confusion, if they're going from pillar to post without any clarity, they'll be worse off.
No, my Lord, that is why I'm grateful to your Lordship. Because, my Lord, a promoter doesn't construct a building for his own use. It is for the interest of, my Lord, two petitions. Your Lordship may kindly come to 1A.
So the philanthropic nature of all your promoters, the great public cause they're serving, we all very well know about that.
No, that's correct. No, that is separate. My Lord, you can't weigh everybody in one. No, that is correct.
You know that builders, promoters all act only in public interest and nothing else. We know that.
No, my Lord, that is a separate, debatable thing.
The commercial interest is only incidental. It's only public interest.
Paramount important. That is a paramount consideration.
Public interest, the commercial interest is only incidental.
That's correct. And simultaneously, my Lord, your Lordship is absolutely correct.
Correct.
I can visualize. I am a businessman.
Correct.
My Lord, I have to also see that the interest of the allottees is protected.
Absolutely.
And my rights are also, my Lord, is duly protected. That is what the RERA says.
Correct.
It is for the interest of the promoter, for the allottees, and for all the stakeholders.
Correct.
Well, it is not a legislation enacted only for the benefit of a group of people.
Correct.
That is for the development of the infrastructure project in the country. It's a burning issue now throughout the country. Lordship may kindly come to 1A.
Right.
Lord, an argument I think was advanced that Societies Registration Act doesn't take care of this formation of association. Lord, I'm sorry, I have to clarify that. Your Lordship may kindly come to 1A as amended by Orissa Act. Let this say state amendment, charitable purpose.
So you have to give us copies, sir.
Milord, I'm sorry, yes, grateful. Milord, I have made a compilation of all the 5 statutes. What are the relevant provisions? That would be of the Development Authorities Act and the rules, the Apartment Ownership Act, the Societies Registration Act, the RERA Act, Milord, the Income Tax Act, everything which is, Milord, the applicable laws for this particular subject. I have given all the relevant provisions.
Right.
Milord, 1A.
No. What is the...
No, I am, Milord, my third argument here. Your Lordship read it 11E. It may be an association. It may be a society. It may be a cooperative society.
All right.
Milord, association, what we ordinarily understand, has a reference to the Societies Registration Act.
No.
1A.
Understand.
Milord, I'm coming to that. It has been interpreted, Milord, in this.
No. 1 minute. What is your ultimate submission?
Yes.
What is your submission? You make your proposition and then we'll read all this. What is your proposition?
Milord, what I objectively argue before your Lordship, formation of an association is the responsibility of the allottees.
All right.
I am a facilitator.
All right.
To enable.
Correct.
Milord, I will ask the gentleman, you see this allotment has been made.
Sir,
it is no majority.
These days you have to be very correct. You can't use only the word gentleman.
No,
there may be many women. There may be many women, sir.
No, that's including me. Yeah. I also come under that.
All right.
All right. Yes. Yes.
Only the lighter note.
Allottees. Meaning your Lordship.
Yes.
Everybody, Milord. I am also an allottee. Your Lordship is an allottee. Everybody comes with that definition.
I don't think we are allottee. Thank God we are not. When one reads all these acts, we wish we are not.
That is what the legislature, Milord, used. Not me. It's not my language.
Right.
So, Milord, 1A. charitable purpose.
No, you have not given us a broad proposition.
Broad proposition is this.
Yes.
Let the formation of association as contemplated under section 11(4)(e) is exclusively a right which is, my lord, belongs to the allottees. A builder doesn't have any right to form an association of his choice and to thrust it upon the allottees that, see, this is the association which I have formed according to me, so therefore you become the members. It can't be. So, my lord, maybe what I submitted, your lordship knows it is a valuable right, 19(1)(c), and this cooperative society was not there. 97th Amendment, my lord, takes care of that from 13. RERA is a subsequent act after 97th Amendment. My lord, even if this 4(e) says about a cooperative society, there is Odisha Cooperative Societies Act, there is Multi-State Cooperative Societies Act is also applicable to the state of Orissa. And there are many associations I have come across all over the country because I am a member, participating member of that national federation, that many of them have registered under the respective state cooperative societies. There is no bar because the act says that. So my duty is confined. It is not, it's my responsibility. I have to enable them. I have to enable, facilitate, to make them congregated in one place or communicate them because somebody.
So will it help to clarify this or it will not help to clarify this?
It would be helpful.
So that is what the state government is all about.
Yes.
So which is why they've taken time to amend the law just to bring more clarity.
No, amendment, that is correct. Your lordship, I am obliged to your lordship because it's a public cause after all.
Yes.
Your lordship, I am really concerned also.
Yes.
So we have to assist your lordship for bringing out a real
Correct.
Your lordship, let the government formulate. There is no bar. It is their domain, their prerogative to repeal law.
Correct.
But the question is whether...
See, also all authorities also need clarity.
That's correct.
So if every association starts getting formed under different laws, then there'll be no end to it.
We'll be grateful, my lord, because
each one will be operating a different domain.
That's correct. That's correct.
The allottees need to the allottees need
We are not opposed to that. We are with the petitioner. Because he is holding the brief for both the sides. Lord Falcon Industries, there are two contradictory prayer sites.
Right.
He is also the petitioner for a promoter. Lord, the read petition number. I am grateful to my lord friend for espousing the cause of both.
Right.
Lord, read petition number.
No, but where are we headed with all these submissions?
I am heading towards, a solution. Because everybody's interest here.
Heading towards
an adjournment and including your lordship.
An adjournment or a solution?
No. Solution means your lordship may clarify.
All submissions will head towards an adjournment. If you see that law by the same government.
Fix a date. Any date.
Let me be given 2 minutes. Ordinarily, I don't ask for time.
Yes.
Okay.
I want to make it very clear.
Yes.
What your lordships intended from the first day of filing of this case.
Right.
Although this side has gone on various tangents.
Right.
Your lordships were concerned only with one section, 17.
Correct.
If I have understood your lordships correctly.
The formation of associations so that common areas can be transferred to that association.
The only concern was that there should not be any sale deed post-RERA.
Correct.
Where the common areas don't go to the association.
That's
short. That is what I've understood was in your lordships.
Correct. And it has to be a composite sale deed. It can't be some,
That's correct.
That is what the act says. All that the lordship said was that, look, RERA has come. 17 mandates the common area should be registered in the name of the association.
Correct.
Please comply with that. That's all.
That's all.
Long and short of this litigation is this.
Correct.
So therefore, your lordships have not injuncted. Rather, I advise the IGR that till this association is there, you don't do it. Now we have stretched to a pre-RERA situation also.
Yes.
And that was never what was intended.
Correct. All right. An affidavit has been filed.
Can I just take 1 minute?
Yes.
Only if I may take to Odisha Development Authority Act. Only I'll read one section. Just 1 minute. Odisha Development Authority Act.
See, Mr. Acharya, you shouldn't have given him this idea now. Exactly. So the more acts you bring in, the more interpretation we'll have to be subjecting.
Yes.
Yes.
If your lordship is having, the court master may assist you.
No, we have this compilation.
Okay.
Mr. Acharya has given us this.
ODI section 20, your lordship.
His duration
of permission.
Correct.
Every permission granted, that means a building permission to construct.
Right.
Granted under the chapter shall remain valid up to a period of 3 years, during which period completion certificate from a registered architect or engineer or a person approved by the authority in the forms prescribed by the regulation shall be submitted. And if it is not done, the permission shall have to be revalidated before the expiration of the period on payment of such fee. Well, my problem is in the first line. The permission will remain valid for a period of 3 years, during which period completion certificate issued by a registered architect. Now, this completion certificate should be issued by a competent authority under the
clarified now. This affidavit. Sorry,
this affidavit clarifies that.
Two submissions. No, 1 minute.
I am not allowed
to
submit.
One side. A, my lords, A is a pre-amended situation. Because post-amendment, your lordship saw 17 only applies post-completion. So what he is now intending, with great respect, my lord, I'm sorry, I never use such words. He wants to go beyond. He is saying that look at the Previous Act.
No.
So 20A says how a completion certificate would be granted, and that is how it has been granted. That's all. Whether you like it or not, it's not the state's problem. You challenge the virus of 20 and get over it. We'll see on appropriate proceeding.
My lord, my humble submission is that anything contrary to after the RERA Act comes post, it is implicitly deemed to be void and repealed under Article 254(1) of the Constitution of India. I have supplied also a judgment, it is on record of your lordship, where
therefore once RERA comes, if you are
not being allowed to submit anything. I have, my lord, I have just supplied a decision way back, it's on record, where the state of West Bengal framed a similar legislation, and the Honorable Supreme Court held that anything in contravention to RERA Act, it is impliedly repealed.
Post-RERA.
So here I am saying only the completion certificate as it is to be issued as per the RERA Act only by the authority.
I think let's not add to what the IGR has
this
said.
much only.
Finally, the IGR seems to have got it right. So let us stick by that.
Yes, that may be record.
The affidavit filed by the Inspector General of Registration on 2nd December 2022. Third December, sorry, clarifies what was meant single quotes completed, unquote, in the public notice dated 14th July 2022, issued by the IGR. Full stop. It is stated in para 4 of this affidavit as under, reproduce the whole of para 4. Paragraph. It is directed that the above clarification now issued by the IGR should again be prominently notified by a corrigendum notification and given wide publicity, so that the ambiguity attaching to the other word single quotes completed in the public notice dated 14th July 2022 is dispelled. Paragraph. Since section 2 bracket Q of the Real Estate bracket Regulation Development Act 2016 implicitly requires reference to section bracket 2 bracket P thereof, both the provisions have to be read together while interpreting the above word. Full stop. The Learned Advocate General states that the process of getting the amended law passed in the State Assembly is underway.
No, it is with the Law Department now, my lords. It will go to the
process have said.
Is in the under process.
The assembly session has got over.
So what do we do?
I think you advance the closure, no? The assembly. I think it got advanced by 20 days or something. Anyway. All right. When do you want this matter to be listed now?
It will come second week, third week.
3rd January, your lordship.
Your lordship has posted this matter to 3rd January.
Already, is it?
My lord.
My lord, may I ask for one clarification? Would your lordship say the present litigation is in respect of the provisions contained under the RERA Act? because people are stretching it
far beyond.
Whose people? Whose people?
Your lordships are seeing. Your lordships are seeing.
If I can say something, my lords, there is a judgment of the Supreme Court which says that completed projects are out of the purview of RERA. Recently, it's come in. We have given that.
Right.
So I think after that, nothing remains.
Then it's better we'll stick to those things.
Yes.
Not anything
Your
more.
Lordship, one prayer, Your Lordship,
Yes.
can kindly, this because Your Lordship knows.
May I only suggest, just half a minute. Your Lordship may take a citation. I'll hand over the judgment. Your Lordship may see para 54 at a, for the next hearing, maybe.
That's there in my convenience note. New text judgment.
Yes, I'm giving.
I have given a copy of that SSC online. And that's CIP based also.
I think in my compilation, it's at page 16. It's digitized.
Your Lordship may see it at leisure, not now. Para 54, just kindly note.
The whole question is question number 1. That has been answered. Beginning from para, yes, para 32 it begins. Answer is in para 53 and 54.
The last line is relevant. At the
Yes.
same time,
yes,
it will apply after getting the ongoing projects and future projects registered.
Yes,
correct. For all ongoing projects, it will work.
That's correct.
Not completed, already completed, or to which completion certificate has been issued.
That completion certificate, the whole question number 1. That has been dealt with. Very vividly it has been dealt with. Yes. Not only
Because
one
the
prayer.
liability under the RERA Act is you can go back 5 years. Suppose today I buy a property under the RERA. For 5 years, the builder will compensate me or make corrections if any construction damage, etc. arises. So this is not as if, so suppose 10 years back when building has been completed, today you can't say it will come under the purview of
Correct. RERA Act.
That's the
Yes.
point.
Correct.
Not one prayer, Your Lordship, sir. IN number 8021 of 2022 at flag Y. That's the application for intervention of this association. Your Lordship, I don't think my learned friend would object to that. So
All
because
right.
I am a stakeholder.
All right. Any other similar applications?
There are lots of applications here. I don't know
You have to allow all of them.
Your Lordship, may any intervention? May.
Which are all those intervention applications? We'll allow them together.
That begins from flag.
My learned seniors intervention may be allowed. Others, I think, are small individual buyers.
That's correct. They are also our members.
So which is yours? IN number?
This IN number 8021 of 2022 at flag Y.
021. You have that in hard copy. It's not bookmarked.
Y. Not Y. It says at flag Y.
No, it's not flag bookmarked.
In the cause list, they have written, yes,
IA number 8021 of 2022. This is an application by an association of promoters. Promoters or builders?
No promoters, Miller. The language
Promoters
is
seeking intervention for the reasons stated therein. The application is allowed. The applicants will be permitted to address arguments in the matter.
My lord, just for a moment.
And file affidavits oblique documents. Right.
For a moment, what came from my learned senior, Mr. Advocate General's wording, and your lordship's agreement to it, apart from the corrigendum, if one line can be added to the order that only those which are post RERA.
No.
So that it will, my lord,
that will come another
clarify.
If everybody understands, mainly it's the registering authorities who have to understand it. And his statement is very clear how they understand it. So that's fine. Once the Advocate General makes that statement, there's no difficulty at all.
That's why I said, my lord.
No, then it doesn't require any further. He will advise the government correctly.
All right.
So,
Obliged.
Then this 11469 of 22 for vacation of stay, whose is that?
114
Because once the Supreme Court has affirmed our order of 24th August, I don't think this will survive.
No, no, that is with regard to some other thing. Let this subsequent order, if you also would look at the order putting a ban on the registration, formation of association, but that is the order dated because they have now come out with this model bylaws. Your Lordship may kindly look at this. This may also be clarified because this association cannot, his prayer is to form the association. The order dated 30th September 2022. Milord is para 5 and 6.
No, they want to vacate the interim order dated 12th May 2022.
No, it is not that.
Yes, that is the. That's
No,
separate.
that is separate. Milord,
No,
this
that's the
para
prayer.
6 may be clarified because the association formation, the RERA, that is his prayer also in the writ petition. To operationalize that the association, they say it can be formed under society's registration.
The government has already made a submission. I don't.
No, that is true.
The government wants to bring in a new law for this.
That is correct.
Not new meaning, amend the existing law. All right. So whose is this 11422?
That may be prior to that. After the apex court's order, I don't think any order is necessary.
All right. In 11469 of 2022, none appears for the applicant. Dismissed for non-prosecution.
No, this
11422 of 22, none appears.
No, my lords, 11469 was filed earlier by the OP number 5. That, as your lordship says, that in view of the Supreme Court order,
that no order can be
it
passed.
cannot be.
No, are you appearing in that?
Yes, yes.
11469. You say in view of the order passed by the Supreme Court on 4th November 2022 in SLP Civil Diary number 28288 of 2022, this application is dismissed. Then 11422 of 22, none appears, dismissed. 11471. None appears, dismissed. Same for 11478. 13705. Who is appearing 13705? Again, none appears, dismissed. So all these numbers you put together, none appears for the applicant, dismissed. All right. So list on 3rd January, the date already fixed. All right. All right.
Obliged.
My lord, I'm sorry, my lord, that 11422, we are the interveners. So your lordship said petition for default. I'm sorry because that.
All right. Same order as in Mr. Acharya's matter.
Earlier intervention.
In 11422, same order as in Mr. Acharya's intervention application. Same order. So you can put both these numbers together.
There is a big disparity, my lords, between fees that side and this side.
But he is the tallest among all.
If I may say, my lords, the learned advocate general has travelled from this side.
And eagerly waiting to go back. Deep obliged.
All right.
That item number 2, I have asked my learned friend to come.
Yes.
This is that case your lordship has issued notice to the revenue secretary.
So it's a revenue and disaster management.
So that he is not the concerned department. We have verified the file here.
So we'll just change that.
Yes.
In item 2.
They are not parties. Your lordship
The affidavit will be filed by the
parties.
Secretary, Panchayat Raj
and drinking water.
And drinking water department. All right.
They may
Panchayat
be
Raj.
included as a party. And
Not necessary, sir, because we are all state of Orissa only.
Para 8, your lordship may kindly see the count.
Right in the beginning, we'll say Mr. D.K. Mahanti clarifies that the concerned department is the Department of Panchayat Raj and
drinking water.
Drinking water. And it is that department which will have to file a reply in terms of the previous orders. And then the order will start. And then you say, affidavit, he says that affidavit will be filed by the said secretary, failing which he will remain present either in virtual mode or physical.
That 25,000.
No, let it be.
My lord, because
otherwise the affidavit will never come.
No,
the affidavit will not come.
No, if that is not come, if we will not file it, we will pay the
that part is over. That part is over.
My lord, because revenue secretary has not done anything wrong. That is my responsibility.
It's only that lawyers will be very happy.
No, on the next day, both the conditions, my respectful submission is that both the conditions should be subject to non-filing of both the conditions. That is my only submission. Both the conditions.
That I'm not changing. All right. Okay.
Item 45, Your Lordship, this was passed over to be heard along with
3rd January. List on 3rd January.
Your Lordship, in item 45, Mr. Palit is on his legs in another court. Your Lordship may be taken up on
3rd. We'll take it up on 3rd.
All right.
Right.
Item 88.
May I please, my lords. For the question, my lords may kindly turn to page 8 of the petition, my lords. Whether in facts and circumstances case, dal and groundnut seeds produced from out of pulses and groundnut constitutes manufacturing for the purpose of entry 26A of the exemption list. 2. Whether in the facts and circumstances case, the petitioner's claim of exemption being under entry 26A of the exemption list, levy of purchase tax relying upon provisions of section 15D of the Central Sales Tax.
Yesterday we were shown this.
Yes, my lord. That Rohini Industries case, because that was also a case I was appearing before the Central Court.
Right.
I am giving the status of the case.
All right.
Because that was a case, your lordship will find I have got the brief copy of the brief also.
Right.
The question framed was that's whether that's this manufacturing of dal out of pulses is exempted under section 8(5) of the Central Sales Tax Act. But as my lords know, section 8(5) is an exemption provision which confers power to the government, my lords, to issue notification.
You want to wait for this judgment? You can. Mr. Sahu points out that the appeal filed by Rohini Industries
now it is admitted by the honorable
has been admitted by the Supreme Court of India.
Second judgment of the second order
and is registered as CA number 2105/2012.
Yes.
And is pending consideration there.
Correct.
List this petition after disposal of the said appeal by the Supreme Court of India. Liberty is given to the parties to mention for listing thereafter.
89.
Increment to continue, lords. Whatever.
All right. Interim order.
Item 89, I need to.
My lords, just
one
small
time
request here. So this matter was, this started in 23rd December 2016, when this tender was first approved. And then this interim order staying construction on the petitioner's land came in 2018. That's 9th of May 2018. Kindly, I request you to allow me time to seek clarification if this tender is still going on or not, because otherwise the matter becomes infructuous, sorry.
You see, Council of the State seeks time to for instructions on whether the tender in question is still alive. At his request, list on. First February. Okay. Interim order to continue.
90.
Please, my lords, item number 90, I pray for the counter copy to be served upon me, and I may be provided some time to file the rejoinder affidavit on the interest part.
Well, covered by my lord's order that Reliance Industries and Jindal.
No, this is not covered at all. This is only confined to the interest part, and 60 lakhs is the outstanding interest from the period assessment year 2007-8 onwards. They were directed to file counter affidavit. Interim order has also been passed in this court by your lordship on 8/8/2019 also, your lordship. So they were asked to file the counter affidavit. A copy may be served upon me, and I require some time to file rejoinder. And batch of writ petitions are also sub judice before your lordships, that in Bharat Motors case. So that Bharat Motors case, it may be tagged up along with that bunch of applications. This is relating to the interest for the previous period. Interest after the Honorable Supreme Court judgment we have paid. So far as the demand of admitted tax to
when is it coming up? When are those interest cases coming up?
This was 16th.
16th of this month?
16th of this month. Yes.
Or at least on 16th.
Well, a counter copy affidavit may be kindly served upon.
If they don't file, they don't file, sir. They have not filed so far. Right.
91.
91, Your Lordship has already admitted the question. Otherwise, needs 1 week time. I have collected the record from the department. Today, I have just entrusted the brief law.
All right, at the request of counsel for the department. List on 12th April. 12th April, sir.
That's it.
Passport matter. Item 23. 23.
And then appeals this.
23, I have instructions to appear for the OP. On behalf of Mr. Pandya.
None appears for the petitioner despite a password. Appellant despite a password. Dismissal of prosecution.
My lords,
1 minute.
My lords, in 52.
So this went up to the Supreme Court and it's come back. This writ appeal. 1 minute. Of the council, is it? Why? All right, you just say right in the beginning, you say against the order dated 26 July 2019, passed by the court dismissing the present writ appeal. The present appellant went in appeal to the Supreme Court of India. Full stop. By an order dated 6th January 2020. While allowing civil appeal number 18 of 2020, the Supreme Court of India set aside the aforementioned order of this court and has remanded the appeal to this court for a fresh disposal in accordance with law. Full stop. A direction being issued to this court to decide the appeal on merits in accordance with law at an early date. Full stop. It has been made clear that the aspect of delay shall not be raised once again. Paragraph. Whose name has to be shown? What it is? On the top, is it? Ramesh Sahu. All right. Yeah. The name of Mr. D.N. Mahapatra be shown as counsel for the appellant, both in the brief as well as in the cause list. Notice will now issue without process fee to Mr. Mahapatra to remain in state. List on.
No copy has been.
9th February.
$52.
Despite a password and appears dismissed.
53.
Please, my lordship. Lordship, there is a defect as notified in the causes.
All right. Defects be removed within a week, list thereafter.
Can it be listed on 19th of December, Lordship? The appearing counsels are coming from Calcutta. They want to physically come and argue the matter. It's a GST matter, Your Lordship. It's 19th of December. I'm asking for
at the request of counsel, the petitioner list on 19th December. Defects be removed by then. All right.
Deeply.
Weekly list. Item number 16.
Which is matters which are over? How do you know that? Which matters are over? How do we know that? You have not. No, here we don't know it.
16 and a 23. On 9. Left on board. Here. 16 and a 23.
Yes.
State's revision, my lord. The question of law is at page 16 of the revision petition. The question number A, whether on the facts and in the circumstances of the case, duplex board was within the meaning of paper as per entry 50 of part 1 of schedule.
It's covered, no? I thought duplex board being paper, only the other day I remember reading a judgment. I read a judgment.
I will verify, ma'am.
All right, counsel the petitioner. State. So, counsel the state seeks time to ascertain if the question raised is covered by a judgment of this court. List in the miscellaneous board. On February 27th.
May I please, my lords? This is a covered matter. My good lordship have already decided this case whether chokered under the Entry Tax Act will be, my lords. I'm just passing on the judgment in Gita Shri, my lords. So,
how come the state has also filed a revision?
So the state has gone for the penalty part, my lords.
Yes, yes.
If this particular matter is answered in my favor, my lord, the state's appeal has to be
correct. Dismissed.
The question of law is at page 7. That the choker will be exigible to entry tax as per entry 66 of part 1 of the schedule appended to the OET Act. Whether the tribunal is justified in holding that choker is liable to be taxed, page 7, lords, at the rate of 1% as cattle feed under entry 66 of part 1 of the schedule under the OET Act, admittedly when choker does not appear in the schedule of the entry tax. Whether the imposition of penalty under section 9, your lordship need not answer this question if the other two questions, my lord, is answered the SSC minutes.
Just answer, I think just frame one question, whether choker is eligible to entry tax as per entry 66 of part 1 of the schedule appended to the OET Act, question mark. Paragraph. The above question now stands answered in favor of the SSC. By virtue of the judgment dated 2nd August 2022 in STREV 31 of 2011, bracket State of Odisha versus Messrs. Gita Shri Industries. Accordingly, the said question is answered in the negative, that is in favor of the petitioner SSC against the state. Paragraph. As a result, the impugn order of the tribunal upholding the liability under the Odisha Entry Tax Act against the present petitioner is hereby set aside. Stop. Consequently, the imposition of the penalty by the tribunal under section 9 capital C bracket 5 of the Act was unwarranted and is hereby set aside. Then in the STR 43 of 2016, by virtue of the order passed today in STREV 32 of 2015 by the SSC against the very same order of the tribunal, the present revision petition by the state is dismissed.
So any amount paid may be refunded.
Sorry?
Any amount paid by the SSC, my lord.
It will be open to the SSC now to apply for refund of any excess amount paid by it in accordance with law.
Greatly obliged.
All right.
Lordships, I'm filing an appearance, maybe.
All right.
Lordships, I think before the department starts, this matter has a maintainability issue. This matter should actually be filed before the Supreme Court, Your Lordships.
Oh, I see.
To Your Lordship, to substantiate my point, the first three judgments which I like to show, when the question occurs that whether these matters should be filed before the Supreme Court or the High Court, the only thing that the court has to look at is the order of the tribunal.
Right.
Your Lordships, I have written all the paragraphs also in the bottom of the page. First, para 10, Your Lordships, I just take through APM Terminals, India Private Limited. Para 10, Your Lordships.
Yes.
It was also urged on behalf of the appellant that the question whether this court has jurisdiction to entertain an appeal would have to be decided on the basis of the question of law proposed by the appellant before it. In the above context, it was submitted that the questions as proposed would not make it a classification issue. This submission cannot be accepted in view of the clear language of 35G1 of the Act, which says an appeal shall lie to the High Court from every order passed in appeal by the tribunal on or after 1st day of July 2000, except where an order of the tribunal relates to determination of question having a relation to the rate of duty of excise or value of the goods for the purpose of assessment. Thus, the jurisdiction to entertain the appeal would depend or be determined by the nature of the order passed. The ingenuity of the advocate in framing the question cannot change the nature and the basis of the order of the tribunal. In fact, whatever be the nature of the question proposed by the appellant, it is for the court to follow the substantial question law in the context of the order impugned. Therefore, if the order of the tribunal is an order relating to the question having a relation to the rate of duty or value of the goods for the purpose of assessment, the jurisdiction of the court is barred by virtue of 35G of the Act. Your Lordship, the similar thing is repeated in both the judgments. One is a 3-judge bench from Bombay High Court. Then another is also, Your Lordship, from Delhi High Court. I would not like to repeat them. Your Lordships, I've marked all the paragraphs. In fact, the Delhi High Court is very straight on the point, which para 3, it says, it is not the content, the appeal, what is determines whether the appeal would be maintainable before the High Court, rather the nature of the order impugning the appeal. Your Lordships, in that note, I would like to take Your Lordships to the order. The order, Your Lordships, is a very small order. If Your Lordships are looking at OTPL 6 of 2015, Your Lordships will find the order at page 63.
Hmm.
Your Lordships.
Right.
May I be allowed to place the order from para 2?
Yes.
The appellant are engaged in the business of providing services of erection, of commissioning, of installation of service and transmission towers, transformers, switch cards, drawing of electric lines, control panels, construction of electricity substation and transmission of electricity to Messrs. Odisha Power Transmission Corporation Gridco and Odisha Power Generation Corporation Limited and others. Your Lordship will then look at para 3. At the outset, learned Advocate Shri S. Mahandi for the appellant has categorically submitted the services rendered by the appellant during the period in the dispute relate to transmission and distribution of electricity. He submits that by virtue of notification dated 27/2010, the central government in exercise of powers conferred under 11C of the Central Excise Act 1944, read with 83 of Finance Act 1994, directed that no service tax shall be required to be paid in respect to taxable service relating to transmission and distribution of electricity for the period up to 21/6/2010. He further submits that the period in the present appeal is covered by the period specified in the said notification. Further, he relies on certain judgments. Here, para 4, Your Lordships. Learned Counsel D.K. Acharya for the Revenue, even though did not dispute the said notification, however, referring to the judgment of Honorable Supreme Court in CCE New Delhi versus Connaught Place Pizza Restaurant, submitted that the notification under 11C of the Excise Act would not wipe away the liability of the pending proceedings against an SSE. However, on direction of the bench, he referred the matter to the CBEC for necessary instruction. He has fairly submitted that in the letter dated 25/8/2014, the CBSE Judicial Cell has clarified that communicated that the observations of the Supreme Court in Connaught Pizza Restaurant cannot be inferred as a ruling precedent as a subject matter.
So they've agreed with you, the tribunals agreed with you that you're entitled to the exemption.
Yes, Your Lordship.
But does this then, the only question is, Is it a dispute regarding classification? It is not.
No, Your Lordship. But the Supreme Court has said right from Naveen Chemicals that when issue arises, whether you are covered under exemption notification, not, it relates to rate of duty. And therefore, Your Lordship, that's why Naveen Chemicals, Your Lordships, I have forwarded
the last
one. Apart from that, I have other judgments clarifying the same point, Your Lordships.
For 11 and 12.
Lordships, I have highlighted those portions also. Questions relating to rate of duty and to the value of the goods for the purpose of assessment are questions which squarely follow within the meaning of the such said expression. A dispute as to classification of goods as to whether or not they are covered by an exemption notification relates directly and proximately to the rate of duty thereto.
All right. Yes, what do you say?
My lord, in this case, if your lordship will come to the question of law, I have framed, my lord.
No, not what you framed. What arises for consideration.
Whether this notification is applicable or not, that is my question of
correct. If it is applicable, they will be entitled to exemption.
My lord.
If it not, they will not.
My lord.
So whether they're covered by an exemption is a question that relates to rate of duty. That's what the Supreme Court says.
My lord, rate of duty is the different because it is the classification of the goods, my lord.
No, this is not to do with classification. Their dispute is not on classification.
Yes, but that's what my lord.
No.
That it is a classification of service. Therefore, it is.
No. She's talking rate of duty, not classification. There's no issue of classification here at all, sir. The question is, are they entitled to exemption under the exemption notification?
My lord.
That they are engaged in transmission of electricity is not in dispute. So there's no issue of classification here. Whether because they transmit electricity, that can be considered to be a service for the purposes of tax.
That is under dispute, my lord.
Correct. So it's only about the rate. Once it's about exemption, non-payment of duty as a result of exemption, it's not an issue of classification at all. It's an issue of rate. That's what this judgment says.
What I pray, my lord, let me go through those judgments.
No. This is one paragraph. You're not adjourning the matter.
Your Lordship,
you just give him the copy of the judgment. You're not adjourning this.
Your Lordship, in the second judgment, the second note, Your Lordship, the Karnataka High Court judgment, it's so clear, Your Lordship. I'll just take Your Lordship's. In fact, I pointed.
No, 1 minute. Let him just. Because the Supreme Court is very clear. Let's not go to neither High Court.
Para 36, Your Lordship, just that. Following Naveen Chemicals.
It only means you file an appeal in the Supreme Court. That's all. You're not being deprived of a remedy.
Then your lordship permit us to file before the...
Obviously. A preliminary objection has been raised by the respondent SSC to the maintainability of the present appeal, relying on the judgment of the Supreme Court of India in Naveen Chemicals Manufacturing and Trading Company Limited versus Collector of Customs, 1993, 4 SCC 320. So it is contended that inasmuch as the dispute emanating from the impugned order of the Sestat concerns the rate of duty payable, rate of duty, the recourse for the appellant department is to file an appeal directly in the Supreme Court of India under section
35.
Under section 35L of the Central Excise Act.
35N.
35L. L for London.
It's given in that.
Of the Central Excise Act, 1944, Bracket Act.
Page 35 of that compilation.
Here. Paragraph. It is seen from the impugned order of the Sestat that the SSC was claiming exemption from payment of duty under a notification number 45/2010, dated 20 July 2010, issued under section 11 capital C of the Act, read with section 83 of the Finance Act, in terms of which no service tax is required to be paid in respect of taxable services relating to transmission and distribution of electricity for a period up to 21st June 2010. Stop. According to the respondent, since the appeal before the Sestat covered the said period specified in the notification, the respondent would be exempt from payment of any service tax. Paragraph. This plea was accepted by the tribunal, by the SESTAT, following earlier decisions of the coordinate bench of the SESTAT. Paragraph. In Naveen Chemicals, the Supreme Court has clarified that, open quotation, questions relating to rate of duty and to the value of goods for the purposes of assessment are questions that squarely fall within the meaning, unquote, of the expression, open quotation, determination of any question having a relation to the rate of duty or to the value of goods for the purposes of assessment, unquote, in section 129, capital D, bracket 5 of the Customs Act 1962, which corresponds to section 35 L. L again, subsection 5.
Subsection 2.
Subsection 2 of the CE Act. Full stop. It has further been clarified that, open quotation, a dispute as to the classification of goods and as to whether or not they are covered by an exemption notification relates directly and proximately to the rate of duty applicable thereto for the purposes of assessment, unquote. It may be noticed here that similar view has been taken by several high courts, including the High Court of Bombay in AP Terminals, India Private Limited versus Commissioner of Central Excise, Navi Mumbai, Manu MH 3535/2018, Commissioner of CGST and Central Excise versus Hindustan Petroleum Corporation, Manu /MH 4297/2021, and of the Delhi High Court in Commission of Service Tax Delhi versus Bharti Airtel Limited, Manu DE 0591/2013, the Karnataka High Court in Commission of ST Bangalore versus Scott Wilson, Kirkpatrick, India Private Limited,
Para 36.
2011 23 STR 321 bracket Karnataka. Paragraph. In that view of the matter, while not entertaining the present appeal, the court leaves it open to the appellant to file an appropriate appeal under section 35 capital L of the CE Act in the Supreme Court of India against the impugned order of the SESTAT, in accordance with law.
Your Lordships, that's 35L or 1B. B. Which
I see. One capital B.
Yeah, my lord, I just want to clarify your lordship. Neither before the so-called authority or before the original authority, appellate authority, they have claimed the exemption under that notification. All of a sudden, before the tribunal, they have shown that notification.
All right.
Because that notification itself gives you retrospective effect.
Right.
It's 11C notification.
All right. So again, same order in OTAP 7 of 2013. You can put down both these together.
Your Lordship, this could be made AFR.
I see. All right. Okay. All right. All right.
Okay. 31.
I may be permitted to submit, my lord, in this particular case. Well, your lordship may kindly turn to order dated 27/4/2016. Your two questions of law have been referred for answering of the lordships, my lord. The first question, my lord, is whether on the facts and in the circumstances of the case, the petitioner being a works contractor, the tribunal was right in taxing the entire gross receipt of the petitioner without allowing deduction towards labor, services, and other charges. The second question, my lord, is whether on the facts and in the circumstances of the case, the tribunal is justified and right in holding that the item electrochlorinator water system is liable to be taxed at the rate of 12.5%, resorting to the residuary entry of Part 3 instead of specific entries under Part 2 of Schedule B, taxable at the rate of 4%. My lords. Here, my lords, your lordship, kindly turn, my lord, to page 34, my lords. Here, the petitioner is a works contractor. He was awarded a work If your lordship may kindly turn to page 34, my lord, of the brief. I've just given a contract, my lord, which was entered with the executive engineer, Rural Works, Water Supply and Sanitation Division, Balasore. Your lordship got it, my lord?
Yes.
Page 34.
Yes.
Now, the lordship may kindly mark the subject, my lord. Award of work, supply, installation, testing, and commissioning of electrochlorinator system at the head work site of PWS Khasafal and so under Balasore block of Balasore district, my lords. And if your lordship would turn over the page, my lords, here, my lords, the details of the bill of quantity, my lords. It says, my lord, the same thing: supply of materials, labor, and transportation and packaging for installation, testing, and commissioning of automatic microprocessors so control salt-based electrochlorination system for generation of sodium hypochlorite solution from common salt having capacity so I need not bother your lordship, my lords. A specific ground, my lord, was taken before the tribunal, my lord, that this particular aspect, that this is a divisible works contract, there is a supply portion and there's a works portion, my lord, was taken throughout, Lord, by the authorities and also before the tribunal, my lords. And in the grounds of appeal before the tribunal at page 31, my lords, at ground number 6, your lordship may see, page 31, my lords. This is a part of my grounds of appeal before the tribunal, my lords. Annexure 6, page 31, my lordship.
Yes, yes.
Ground number 6 is the department order to the appellant to supply all materials, labor, and TP for installation, testing of the pumps, water chlorine to pump out impure water for getting purified water, which be treated one kind of works contracts specified in the for the order. The department also made TDS VAT from the bills when credited to the appellant. The in assessment order, TDS being credited, which is illegal and away from justice.
So you said this has not been considered.
This is not at all considered. So I was only praying, my lord, subject to your lordship's kind consideration.
Send it back.
It has to go back, my lord, and let the second question be also answered by decided by the tribunal.
That second question, they seem to have already answered the electrochlorinator.
They have done it, but in my humble contention, my lord, they have not done it correctly, my lord. Your lordship knows that so far as this electrochlorinator is concerned, my lord, it's an entire system, essentially a pump, my lords. For pumps and pump sets, my lord, there's a particular entry under the OVAT Act, my lords. And the tribunal, my lord, they have also, my lord, quoted that provision, my lords. And
but is it a centrifugal monoblock or submersible?
Malus. So, my lord, this chlorinator system, even though, my lord, it is something to do with electrolysis, so to convert the salt water, add chlorine to it and make it potable, my lords. This essentially, my lord, is done by a pumping mechanism.
No, I don't think that's different. So this is a very specialized product. No, it's not just an ordinary pump. It does not only perform this function of being a centrifugal monoblock pump.
No, your lordships are correct. It's electrolysis plus a pump and a chlorinator, my lords, if I've understood it correctly.
That's right. There are several components.
Which go into the system.
Correct.
But the major
part can't be separated out. The minute you remove the pump, there's no longer that product.
So my humble contention would be subject to what falls, my lords.
Right.
It's essentially a pump set or a pumping mechanism.
Right. No.
With
then. It's not only a pump. Correct. And it shouldn't do any other function. It should only be the pump. Here it does many other. It filters out, converts.
Yes. So, my lord, the entry to serial number 21 is centrifugal, monoblock, and submersible pumps and pump sets for handling water operated electrically or otherwise, and parts and accessories thereof.
Correct.
So my humble contention would be, my lord, the pump is there, my lord.
Right.
The electrolysis part and the chlorinator part
have to separate it out. That's all.
Assessing authority finding.
So at least for the first
water purifying.
So the first part, my lord, has not been at all considered. No.
So this question we will not entertain. Only on that other question you can send it back. I don't know if it will make a difference to your assessment.
It will make, my lords, because the labor and service
component
goes out, my lords, and then
he has to produce his books of accounts.
Correct. You see, the following questions have been framed by this court for consideration in the present revision petition, arising from an order dated 4th December 2015, passed by the Orissa Sales Tax Tribunal Cuttack bracket tribunal in essay number 328 bracket 5 oblique 2014-15 filed by the present petitioner SSC. Then put down colon and take the two questions from the order dated 27th April 2016. Two questions are there. Paragraph. As far as the first question is concerned, as far as the second question is concerned, the product which was asked by the which was asked to be installed by the present, which was asked to be installed
the petitioner.
One. No, the product in respect of which a work order was issued in favor of the petitioner SSC for supply, installation, testing, and commissioning was an open quotation electrochlorinator system, unquote. Full stop. The question before the authorities was whether this electrochlorinator system can be regarded as single quotes centrifugal, monoblock, and submersible pumps and pump sets, unquote, as found in serial number 29 of part Roman capital 2 of the Orissa Value Added Tax Act, bracket OVAT Act, and taxable at 4%, or whether it was an unspecified item covered under part Roman capital 3 of Schedule capital B of the OVAT Act, liable to be taxed at 12.5%. Question mark. Paragraph. The relevant entry at serial number 29 reads as under, take from page 40, that whole of serial number 29, paragraph. While it is argued by Mr. Karel, learned counsel for the petitioner, that the electrochlorinator system is essentially performing the same function as a centrifugal, monoblock, or submersible single quotes pump, unquote, it is not in doubt that the said system does not perform only that function. Full stop. It is comprised of components, one of which acts as a single quotes pump. Full stop. Otherwise, it converts salt water into potable water, which is its essential function. Full stop. In other words, it's a specified product. It's a special product for discharging a specific function. And one component of that product is a single quotes pump. Full stop. In the circumstances, the court is unable to agree with the above submission that the said product would be covered under serial number 29 of part 2 and would be taxable at 4%. Full stop. Consequently, as far as question number 2 is concerned, it is answered in the affirmative, that is in favor of the department and against the petitioner SSC. Full stop. The court therefore declines to interfere with the impugned order of the tribunal as far as question 2 is concerned. Paragraph. Now turning to question number 1, it is seen that although the petitioner SSC had specifically raised a ground before the tribunal that
Page 31.
It was in your written argument, is it?
My lords.
Had raised the ground in its written arguments that
Para 6 minutes.
Which ground is that?
The para 6 minutes. And the same ground was also taken before the first appellate authority.
The department order. That one. That isn't clear. No, it's not worded properly, sir.
I'm sorry, Lord. The wording is not because they have borrowed it from whatever was taken as the first appellate authority.
Yeah,
it's not correctly worded, Lord.
Right.
Lordship may say it's a type of works contract.
Yeah, that the work performed. Yeah, that the work order issued in favor of the SSC was one form of works contract. And that the value of the work order had components of labor and service charges. This aspect does not appear to have been addressed by the tribunal. Full stop. Consequently, the aforementioned essay number, whatever that is remanded to the file of the tribunal only for considering whether the authorities were right in taxing the entire gross receipts of the petitioner without allowing deduction towards labor, service, and other charges. Stop. For this limited purpose, the appeal will now be listed before the tribunal on 1st February 2023, on which date the petition will appear either through an authorized representative or counsel. Or should we send it back to the assessing authority? No, we've framed only 2 questions. Questions have been framed is only 2. We can expand it this now. Yeah. No, only 2 questions have been framed. So it goes back to the assessing authority. I don't know how it happens.
Tribunal, in fact,
that question has not been answered by any lower forum.
Because that was also a specific ground.
In fact, you've not raised it actually.
No, your lordship may see in first appellate authority.
No, but was it actually raised before?
My lord, your lordship may see page 24, my lord, before the first appellate authority also. Page 24 of the brief, my lords. Small Roman 3, my lords. It can go back to the assessing authority. That has to be bifurcated. That has to, your lordship are correct. Your lordship may send it to the assessing authority also. Because page 24 is the part of the first appellate order, my lords. Small Roman 3, my lord, that was also a question before the first appellate authority.
And what is the first appellate authority?
Nothing, my lords. They just go on electrochlorinated.
All right, just before that you say, it's a scene that this issue was also raised before the first appellate authority.
Small Roman 3 at page 24.
Yeah, but not addressed by it. Full stop. For the aforementioned reasons, the court permits remands the matter to the assessing authority. That is the sales tax officer. No, what is it now called?
No, sales tax officer.
No, now no longer serves.
Sales tax officer, city GST, my lords. City and GST, Balasore Circle, Balasore.
To the assessing authority, that is the CT and GST Baleshwar Circle.
Sorry, states. I'm sorry, my lord, state tax officer.
Or the state tax officer Baleshwar Circle for examining the above limited question, namely whether the entire gross receipts of the petitioner, without allowing deduction towards labor services and other charges, should have been brought to tax, ? For this limited purpose, the matter will now be listed before the said assessing authority on same date, on which date the petitioner will appear with all its books of accounts for the relevant period. Which is what? Which is this period now?
The period, my lord, is
2007-08, 2008-09. Okay.
7889.
The petition is disposed of in their own terms.
Greatly obliged.
32. May I please, lords? The question of law is at page 7, my lords. Whether in the facts and the circumstances of the case, the learned authorities below are justified in not accepting the reversal made by the petitioner in the returns when the same were submitted prior to reassessment and the determining the GTO and TTO without giving credit to the tax paid on such reversal. And second is the consequential question, my lords, regarding penalty, whether in the facts and the circumstances of the case, the learned authorities below are justified in levying penalty in absence of any finding with regard to the malafide intention of the petitioner to evade or avoid tax or any allegation with regard to
No, this is under 42.5. This is not under the OVAT or OST?
OVAT.
So 42.5 is attracted, no, for this penalty?
42.5, just.
So we're only on question number 1.
Question number 2 is consequential. If question number 1 is answered, my lords, question number 2 is automatic.
Correct.
What has happened during the implementation of VAT? The petitioner was not aware about the provisions of the law regarding the reversal of ITC, non-availing of ITC in case of goods which are being consignment sale in respect of consignment sale or branch transfer. Subsequently, when in course of audit, the audit officials pointed out the mistakes or enlightened the petitioner with the provisions of law, and thereafter a revised return before the assessment was filed by the petitioner. That has been that submission was made before the authorities below, that my revised return may be accepted, and the reversal which has been done in the revised return may be accepted. That question, my lords, has not been answered by the authorities. My lords, may kindly see page 22 of the brief, the tribunal order, my lords, Annexure 3. May I please? Page 22, my lords. Question number 3. Learned counsel appearing on behalf of the appellant reiterated the points mentioned in the grounds of appeal. Accordingly, the appellant has estimated the disallowance of ITC to the tune of rupees 1,48,000 somewhat, and accordingly reversed rupees 1,27,000 and deposited it in amount before the reassessment proceedings. And such the penalty should not be charged on the said amount. Thereafter, my lords, page 23. While deciding my appeal, the tribunal, page 23, para 5, 3 lines from above, here the learned authorities, my lords, below have disallowed the ITC availed with due regard to section 23E of the OVAT Act. Accordingly, the input tax credit on purchase intended in case of transfer of stock of taxable goods other than by way of sale to outside the state shall only be allowed in respect of amount of tax paid or payable in excess of 4%. When a registered dealer dispatches both taxable and exempted goods under this act, the input tax credit shall be appropriately allowed only to the goods which are not so exempted. Here in the instant case, the case of the appellant deals in rice, which is subject to tax at the rate 4%. So it can be said that the authorities below are wrong in disallowing the ITC in terms of the provision under this section mentioned above. I admitted that I should not have taken the ITC, and therefore I have filed a revised return reversing my ITC before in course of reassessment. And my lord, Rule 46 says that In course of audit, my lords, I'm just listing that. In course of audit, the audit officer has to facilitate.
The rules.
Page 297, my lords.
Yes.
Now, it's the audit to facilitate voluntary tax compliance. And this tax compliance is important. The audit team during an audit visit shall explain the provisions of the Act and these rules so that the dealer does not face any difficulty in maintenance of books of account and due discharge of tax liability matters. Taking aid of this provision, the audit officer advised me that this transaction needs to be reversed by the ITC. I have accordingly reversed the ITC and filed a revised return before in course of reassessment, before the assessing officer. If that is being taken into consideration, my lords, no further demand should have been made, my lords. What the assessing officer has done, that has been, instead of taking my returns, he has further disallowed my ITC and the consequent penalty has been imposed, my lords. That my humble
already
service,
reversed.
my lords.
And you've already reversed it.
Already reversed by the revised return, my lords.
33(4) stipulates 3 months time to revise his return. Section 33(4) stipulates him to revise his return within 3 months.
Yes. Yes, madam. That is there, my lords. But during the implementation of VAT and my lords, 33(5) may kindly be seen that proviso, which my learned friend is insisting. The proviso, my lords, I am placing that proviso, my lords, at page 56, madam. Provided that the proviso to which they are referring, provided that no such voluntary disclosure shall be accepted where the disclosure is made or intended to be made after receipt of the audit or notice of the tax audit under the Act. Thereafter, one amendment has been brought where from which 3 lines has been deleted. My lords, kindly see the footnote. Or as a result of such audit. This has been omitted with effect from 1/10/2015, my lords. So prior to that, it was consciously allowable, my lords.
After audit also, you could.
Yes, my lords. Yes, my lords. And my lords, may kindly see the language, voluntary disclosure, my lords. Here, in my case, there is no disclosure. These I have
no, but the proviso says no such voluntary disclosure will be accepted.
My lords,
Therefore,
the
not be accepted where you make the disclosure in the course of an audit.
In course
as
of
a result
of such audit, my lord.
So the blank, it's a ban on, it's a bar on accepting the voluntary disclosure.
But till 1/10/2005, prior to 1/10/2005, I can file after audit also, my lords.
No. But no such voluntary disclosure shall be accepted.
My lords, can it be a
First
voluntary?
line of the proviso, sir.
My lords, as a result of such audit, man.
No, which means just read the whole thing now.
Yes, madam.
Provided that no such voluntary disclosure shall be accepted.
Where the disclosure is made or intended to be made after receipt of the notice for tax audit under this Act or as a result of such audit.
You made the disclosure, you've reversed only after the audit.
My humble submission is that
So this proviso actually goes against you completely.
Yes, my lords, but my lords have to see that whether this voluntary disclosure will. I have shown my turnover. All the gross turnover, GTO and TTO have been disclosed.
They expect you to do it voluntarily before either they conduct the audit and before they complete the audit.
Notice is issued.
So on you, that is what is voluntary. Not after you received the notice of audit or you got the audit report. Not after that. That's it, sir. Two questions were framed by this court for consideration in the present division petition, while admitting it on 20th November 2017, reproduces those two questions. Paragraph. As far as the first question is concerned, it appears that in the course of reassessment, the assessee filed revised returns, and in those revised returns, reversed the input tax credit bracket ITC wrongfully claimed by him earlier. Full stop. The question that arose is whether the authorities were obliged to accept this reversal of entries and therefore not raise the demand against the petitioner in the reassessment proceedings, question mark. Admittedly, the revised returns were filed beyond the statutory limitation period of 3 months, as provided under section 33 bracket
5, 33.5.
3 months is 4, 33 bracket 4 of the Orissa Value Added Tax Act 2004 bracket OAT Act. Paragraph. The proviso to section 333 bracket 5 of the OAT Act imposes a bar on acceptance of voluntary disclosure, which was made open question after receipt of the notice for tax audit or as a result of such audit. Unquote. In the present case, the wrongful availment of the ITC was detected in the course of audit, and it is only as a result of such audit report that the petitioner sought to reverse the ITC wrongfully claimed by filing revised returns. Full stop. Consequently, on a combined reading of section 33 bracket 4 and section 33 bracket 5, the OAT Act, it is plain that the authorities could not have accepted the voluntary reversal of the wrongfully claimed ITC by the petitioner. Paragraph. In other words, the impugned order of the tribunal upholding the demand does not call for interference. Question number 1 is accordingly answered in favor of the department in the affirmative, that is in favor of the department, the assessee. Paragraph. In view of the answer to question 1, question 2 is again answered in favor of the department and against the assessee. The revision petition is accordingly dismissed.
Obligation. 33. My lord, in item 33, both the items are related to 2J issue onto entry tax. Similar matter is posted for my lord on 6th of February, my lord.
Or list on 6th February. Along with STREV? Do you know, have the numbers?
My lord, I'm sorry, I don't have my lord.
All right.
I will provide them.
34.
My lord, in active item 34, I am challenging the levy of penalty under section 43, subsection 2 of the OVAT Act, lordships. My lord, the petitioner is a manufacturer of transformer, which is subject to GST, subject to VAT at the rate of 4%, your lordships. Apart from that, also, my lord, the petitioner also undertaken the reconditioning and repairing of transformer for Westco and Southco to electricity boards, your lordships. And as per the purchase order issued by the said company, they have directed to levy VAT at the rate of 4% on such reconditioning and refining transformer, which is in usable working conditions. So on the bona fide bill bar, since the transfer is subject to tax at the rate of 4%, and the reconditioning and the electricity board also certified that they are supposed to charge VAT at the rate of 4%. I have collected the VAT at the rate of 4%, your lordships. So in the order of assessment, a differential tax has been levied, your lordship, on the furnace oil, demanding tax at the rate of 12.5%. But there is no finding in the order of assessment that the imposition of penalty under section 43, subsection 2 was in absence of any reasonable cause, your lordship. Unlike the assessment under section 42, subsection 5, the levy of penalty under subsection 5
automatically and mandatory on the assessed amount tax. That principle is not laid down by under section 42.5. Let me read out the relevant provisions of section, my lord. If the assessing authority is satisfied that the escapement or under-assessment of tax on account of any reasons mentioned in subsection 1 above is without any reasonable cause, he may direct the dealer to pay by way of penalty a sum equal to the previously it was twice, the equal to the twice the amount of tax additional assessed under this section, your lordship. And this is already decided by my lord in the review petition in the case of Nalco, your lordship, in 211 of 2013 on 28th of March 2021, lordship, is para 12, my lord. Let me place both the orders, my lords.
Yours is a 43-2 penalty, not 42-5.
My lord.
It's a 43-2 penalty.
My lord.
Not 42-5.
No, my lord. It is 43-2 penalties. Para 12, page 4, my lord, of my lord's order. I may read out, my lord. Page 4, my lord. It is seen under section 43.2 of the OVAT Act, the levy of penalty in the event of turnover escaping assessment or under assessment is not automatic. The AO has to satisfy that the escapement or under assessment tax is without reasonable cause.
Here, what is the reasoning here for that penalty? Let's read that.
The findings of the London Sales Tax Officer, your lordships, kindly have to glance to the page 29, my lord. The last para, my lords.
This is United Electricals, right?
Yes, my lord. The last few sentences, besides tax, further penalty of 3,54,524 has been imposed under section 43.2 OVAT Act, a sum equal to twice the amount of tax additional assessed.
So without actually any finding.
Exactly, my lord. I am obliged.
Finding is prior to that, my lord.
What?
That is with regard to levy of tax. I am not disputing with regard to levy of tax, my lord.
No, let him
that page 28. Last paragraph. Erroneous claim of ITC. On verification of returns, it is found that a dealer has paid input tax credit of such during the tax period under assessment and carried forward ITC of such from the previous tax period. He has adjusted VAT such against CST and adjusted ITC such against collection of VAT output tax. On verification of returns, it is detected that the dealer has availed ITC of such against purchase of 12.5% taxable goods, value of such, but he has affected corresponding sale of 4%. Hence, he is liable to reverse ITC of such.
Where is the finding, sir? If the assessing authority is satisfied that the escapement or under-assessment on account of any reason mentioned is without any reasonable cause, where is that finding? It's not there at all. That finding is not there.
He has availed excess ITC.
That it is without reasonable cause, sir. Not mere availing is one thing. That should be without reasonable cause. That finding is not there. All right. While admitting the present revision petition of the petition assessing against the impugned order dated 7th October 2015 of the Sales Tax, Orissa Sales Tax Tribunal, Tribunal, dismissing essay number 353, VAT of 2013-14 filed by the SSC. This court framed the following questions for consideration. Take from 31.8 2016 order. Paragraph. As far as question 1 is concerned, it is seen that in the assessment order dated 5th February 2013, while sustaining the demand, while raising a demand on the basis of single court's erroneous claim of ITC, comma, the sales tax officer bracket STO, Ganjam 1 Circle, Berhampur, proceeded to impose penalty under section 43 bracket 2 of the Orissa Value Added Tax Act 2004 bracket OAT Act without actually coming to any conclusion that the ITC wrongly availed by the petitioner SSC was open quotation without reasonable cause. Paragraph as explained by this court in what's the original NALCO judgment citation? Whatever. In National Aluminum Company Limited versus State of Orissa.
Deputy Commissioner of Police.
Deputy Commissioner Commercial Taxes 2012 56 VST 68. Read with the clarificatory order dated 8 March 2021 in review petition numbers 211, 212 and 213 of 2013, comma. There is a discretion in the assessing officer under section 43 bracket 2 of the OAT Act to impose penalty. Full stop. It is imperative for the AO to be satisfied that the escapement or underassessment of tax, open quotation, is without reasonable cause, unquote. Paragraph. There can be no doubt that as far as the present case is concerned, the order of the assessment order of the AO does not record the satisfaction of the AO that the wrongful availment of ATC by the petitioner was, single quotes, without reasonable cause, unquote. Thus, an essential component for attracting penalty under section 43 bracket 2 of the OAT Act, namely satisfaction of the AO that the escapement of tax was without reasonable cause, is absent in the present case. Paragraph. Accordingly, the question is answered. Question number 1 is answered in the negative. That is in favor of the petitioner and against the department. And the impugned order of the tribunal and the corresponding orders of the first appellate authority and AO, levying penalty on the petitioner under section 43 bracket 2 of the OAT Act, is hereby set aside. Paragraph. In view of the answer to question number 1, question number 2 need not be answered. The revision petition is accordingly disposed of.
My lord, that is ITC along with the differential tax.
Okay. ITC with differential tax. All right. All right. Okay. All right.